Yeah, I had to sneak out
To
real
cancel
quick.
my traffic. Yeah, that would be wonderful.
It's a weird time of the day. Try to make sure everybody has.
Okay, everyone, we're going to call this meeting to order. We're live with the recording and the court reporter, so we'll get moving. We'll start off with a roll call of the members.
Mr. Zollinger,
Here.
Ms. Boykin,
Here.
Ms. Clevenger,
Here.
Mr. Strutt,
Here.
Mr. Lemuel.
Here.
Yeah, all members are present, so we have a quorum, obviously. There are 5 of us, so that means any action we take will take at least 3 votes. Whatever motion we take, it'll take at least 3 of us to move that motion forward. The next item of business is the minutes for consideration of the September 27th, 2022 minutes. We've all had an opportunity to review those. We've been provided those, so I will entertain a motion to approve the minutes of September 27th.
I move that we approve the minutes.
All right, second.
Second.
All right, do a roll call vote for the minutes.
Mr. Strutt,
Yes.
Mr. Lemuel,
Yes.
Mr. Clevenger,
Yes.
Ms. Boykin,
Yes.
Ms. Clevenger, Mr. Zollinger.
Yes. Yeah. All right, then now we'll move on to the appeal section of the agenda. Go ahead and read out both appeals for me, please.
Application number 22 NC ZBOA-0005, Christopher Swing Esquire, 1474 North Main Street, North Canton, Ohio, 44720. An appeal from August 3rd, 2022, Planning Commission preliminary and final approval of General Development Plan 22 NC PC-0008. Application number 22 NC ZBOA-0007, Christopher Swing Esquire, 1474 North Main Street, North Canton, Ohio, 44720. An appeal from August 30th, 2022, Planning Commission approval of conditional use permit for gasoline station accessory to retail 22 NC PC-0008.
Thank you very much. So this, we're here, it's to consider an appeal of 2 rulings of the Planning Commission. And this is sort of, this board, what we normally work on are variance requests. But under Section 1179.01 of the ordinance, we also have the ability to hear appeals of city officers and city commissions, such as the Planning Commission. So we're here to address an appeal of 2 decisions, one from August 3rd, 2022, and one from August 30th of 2022. We decided at the September 27th meeting to hear these appeals together because they concern a lot of the same evidence and testimony. I would suggest we do, if everyone else on the board and the parties are okay with it, is to have any testimony or arguments address both appeals at the same time, and to the extent you are arguing for or against one appeal where there's a difference, you can highlight that. And then when we take action on these appeals, whether to reject or affirm the appeals, we will take the action separately as they are delineated on the agenda item. As with the Planning Commission meeting, this is an adjudicatory proceeding. There will be no public speak section. This is more like a court proceeding. I will be presiding over it. The other board members will also be entitled to ask questions, and of course, everybody here gets to vote in their own way. The other point I would like to make for the benefit of the parties is we have all been provided the transcripts of both hearings, all of the evidence that was submitted. I've reviewed everything myself. I've watched the videos of the proceedings. I'm aware of the evidence and the issues. The parties will be entitled to present whatever evidence they want, whether it's new or old evidence, evidence from before. They can present it again to us, or they can rely on what was presented before and just direct us to where it is in the record here. But you're going to be allowed to make whatever record you want today. As far as I understand it, and people can tell me if I'm wrong, our decision, we make our own decision here. We don't give deference to the rulings below. So these are going to be our decisions, individually voting members and as a board. So Mr. Swing is the appealing party in both of these. I don't know if anybody has any suggestion on how to proceed. I would suggest that we do this like a court proceeding where counsel for the parties can get up and make an opening statement, basically outline their position, and then each one will get a turn to do that. And then if there's any witness testimony or any other evidence that they want to put on, Mr. Swing will have an opportunity to do that. And then there'll be those, any witnesses will be subject to cross-examination by the city, and then the city will get a chance to go and present its evidence with the appellant having the opportunity to cross-examine there. Does anybody have any issues with proceeding in that manner?
No.
How about from the parties? Anybody?
May it please the board, on behalf of Albrecht, we do object to having these administrative appeals combined.
Okay, thank you. I don't know if do we need to take action as a board on whether to overrule that objection? I feel like, or to sustain it. Because I feel like we probably,
Najib McClue for the city, I think, from my perspective, I prefer that the board to take action based on the objection, to make a ruling on the objection. But the point of clarification is, my understanding is that here, the actions are not being combined. This is the hearing consolidated, but they're still being heard as two separate actions. It's for convenience of the witnesses, for convenience of the parties, instead of having somebody stand up there, testify, sit down, and then stand up again and testify, and to avoid repetitive testimony, but that the board is taking separate actions on both. So it's the hearing for the convenience of being heard together, but we're not combining them, is not the right terminology.
okay.
May it please the board. There are two separate records below that the board is bound by, and to include them together is to muddy those issues. There are different legal standards, different legal issues, different zoning code provisions, and there's a different record of proceedings with respect to each of those applications. So this ought not be an opportunity to back and fill, to supplement a record of proceedings that should have been developed for the planning commission. And so we object on that basis. And we also agree that while the board is not obliged to give deference to the planning commission, the board is bound by the same record of proceedings. So with that, I'll sit down and we'll get started when you guys are ready.
Right.
I apologize. I have to clarify one point, which is, yes, there are two separate records from the planning commission. Nobody's arguing anything differently, and we think the board is sophisticated enough to be able to understand the evidence that pertains to each. But the one issue that I wanted to clarify is the zoning code in section 1179.07 specifically provides that this board shall have the powers of the officers from whom the appeal is taken. So this board itself has the power to almost sit in as if it were the planning commission and make its own independent judgment. So the idea that we're not stuck with we're very satisfied with the state of the evidence as it is, but neither the appellant nor us are stuck with the evidence exactly as it's verbatim before the planning commission. Each party has the ability to supplement it, and the board has the ability to make its own decision.
All right. Thank you. Well, because this is why we continued the hearing from September 27th. We thought it would be more expedient, more efficient to address both issues at the same time. Again, we're going to allow the parties to present whatever evidence they want on both issues. Just, obviously clarify for us what issue you're addressing, if there's something different, or what standard should be applied with respect to each of these. So I'm going to make a motion to overrule the objection and hear evidence just once with respect to these, and with the understanding that, we are hearing two different issues, and we're not combining the issues. Have a second?
Second.
Why don't we do a roll call on this?
Ms. Boykin?
Yes.
Ms. Clevenger,
Yes.
Mr. Zollinger,
Yes.
Mr. Stroud,
Yes.
Mr. Lemuel,
Yes.
Okay, the objection is overruled. So what we will do then is, Mr. Swing, if you'd like to go ahead, and we'll let you go first since you were the appealing party. I'll give you a chance for rebuttal as well after the appellee presents its case also.
Thank you.
Okay? Yep.
May it please the board, Christopher Swing, I'm here on behalf of Albrecht Incorporated, which is the true party in interest of the applicant here this afternoon. It's partly this issue of expediency and efficiency and hurriedness and haphazardness and getting things out of order that is giving rise to this appeal. And so I would strongly encourage the board to slow down, to keep the issues separate, to appreciate that there are different records for each of these issues. I disagree with Mr. McLuth in terms of while you may be able to exercise the same authority, you don't have the authority to expand the record today. You're bound by the record. And so while you may substitute your judgment for the planning commission, you can't back and fill the record that's already been established. You are charged with reviewing the administrative record concerning the planning commission's grant of the preliminary and final approval of a development plan to construct a Meyer store. You are charged with determining whether the record before the planning commission was sufficient on August 3rd, 2022 to support the fact that the goals and requirements for all Main Street districts, including the North Gateway District, are satisfied, and that the express requirements for approval of a development plan are expressly satisfied. That's the issue with respect to the final development plan approval. With regard to the conditional use, if the board is going to insist on having them presented this way, you are charged with reviewing the administrative record concerning the planning commission's grant of approval of a conditional use permit for a gas station accessory to a Myers planned principal use, and determining whether or not the record before the planning commission as of August 30, 2022 demonstrates that the goals and requirements for all Main Street districts, including the North Gateway District, have been satisfied, and that the general and specific criteria for all conditional use applications have been satisfied. It was the applicant's burden of proof below before the planning commission. The applicant had every opportunity to make the record before the planning commission. And the decision this afternoon, and the one that was made by the planning commission, cannot be unreasonable, it cannot be illegal, cannot be arbitrary, cannot be capricious. And I would submit to you respectfully that the applicant did not satisfy its burden of proof below. I'm going to take these in order. First, with regard to the development plans. At worst, the preliminary plans that were submitted to the planning commission evidence that they violate the city zoning code. And at best, they evidence that they are insufficient and raise more questions than they answer. And for those reasons, the planning commission's decision must be reversed. Albrecht set forth the bases for its objections on the record during the planning commission's adjudication hearing on August 3rd and August 30. And on August 3rd, at the beginning of the public meeting portion of those proceedings, the planning commission expressly incorporated into the public record the development plan, all of the material that had been raised with respect to the conditional accessory use for the gas station. There are several items attached to the agenda item report today that were not before the planning commission on August 3rd when it granted preliminary and final development plan approval. And it was not made part of those record of proceedings. So the question was, at that time, was the record sufficient to support what the planning commission did? Because it's the planning commission that is vested with authority to make decisions with respect to the preliminary and final approval for those plans. The applicant did not submit with its application a traffic study on August 3rd. That came later. And then only in regard to the accessory use. The applicant did not submit a stormwater management plan, a wetland delineation study, a reported replatting of the parcels. These conditions are express requirements of approval of a development plan under 1175-07, A4, 6, and 10 of the zoning code. The planning commission was required to determine at that time that there were adequate provisions made for the safe and efficient pedestrian and vehicular circulation within the site and to adjacent property. Again, the traffic study was not even presented that evening. Was not part of the August 3rd record. The development will preserve and be sensitive to the natural characteristics of the site in a manner that complies with the applicable regulations of the zoning code. It was required to determine on August 3rd in regard to the development plans that there adequate provision was made for storm drainage within and through the site so as to maintain as far as practical, usual and normal swells, water courses, and drainage areas. The planning commission could not make those determinations on August 3rd because on August 3rd, there was no traffic study that was submitted. There was no traffic remediation plan that was submitted. There was no stormwater management plan that had been considered or submitted. There was no wetland delineation study at that time when the planning commission approved the development plan on August 3rd. There was no environmental remediation plan for the extraordinary contamination on that site. Approval was not appropriate of the development plan because the general development plan does not conform to the requirements of all Main Street district regulations, including those set forth in 113601. And again, at the risk of being repetitive, 113601, your zoning code was rewritten. It was overhauled and it expressly prohibited gas stations. And what it did was it intended to promote pedestrian-friendly mixture of storefront, retail, professional offices, building with active building facades set at or near or close to the sidewalk, and a development, again, pedestrian-oriented scale with sidewalks wide enough for the activation and regularly spaced street trees to promote a walkable environment. Notwithstanding, your own expert back on August 30 testified that this area is not suited for and not intended to be a walkable environment. And I would respectfully ask the board to consider, why is it then that the 113601 and 02 provisions apply to all of the zoning districts on Main Street? And the city's expert testified and he agreed it applies to all the districts, not just the central corridor or the south gateway. It applies to all. The record does not demonstrate that the development plan will meet the building design standards applicable to all Main Street districts set forth in 113609. There's no evidence the structures will meet the specific material and design element requirements of 113609. The development plan includes a standalone gas station, and it doesn't matter how you characterize it as an accessory use. You can't make it an accessory use just by calling it an accessory use. It's an independent standalone gas station. This is insufficient to show that there's a general development plan that is consistent with the orderly development for the city and this very important corridor for the city. The applicant has not presented any evidence on how it intends to address the extensive and longstanding serious and historical dumping of hazardous materials and environmental contamination at the site. Nobody has presented a plan for satisfactorily and safely addressing it. Without the information, the Planning Commission could not properly determine that the general development plan, quote, is consistent with a plan for the orderly development of the city and that the appropriate use and value of the property within and adjacent to the area will be safeguarded. Moreover, without a copy of the purchase agreement, which we've asked for repeatedly and we've been denied repeatedly, it's impossible to know where the responsibility for these things is going to lie. For example, with respect to the estimated infrastructure improvements for the roadway, the city's expert testified it was a ballpark, $1 million. Okay, put that in relation to the purchase price of the property, and there's a reason for that. The project and the zoning approval sought have been hurried, haphazard, out of order, and unsupported from the beginning. What is apparent in the record is that the city had entirely different plans for the real estate in 2019 when those plans subsequently fell through. Stuck with a highly contaminated and toxic property that it overpaid for, the city was desperate to offload it. And it turned 180 degrees to entertain discussions with Meyer of retail grocery use, a use the city had recently disavowed publicly in public comments attributable to at least one city councilman and the economic director. City council then hurriedly and haphazardly purported to change the zoning to accommodate Meyer's desired gas station. Um, And it's evidenced, if you just look at the zoning code, you guys didn't catch up and make all the changes in the zoning code you should have made, and there are typographical errors in the zoning code. It references accessory to a 55-acre parcel, when what was intended, I'm sure, was a 5-acre parcel. It says different things in the ordinance versus what's in the zoning code. It's obvious that it was hurried. Moreover, there's also a conflict in terms of accessory uses being only permitted in that zoning district for residential. So before a clear understanding of what was required to remediate the environmental contamination, and months, maybe years before we're ever able to know or get that certainty, right? Because again, the city's expert testified there's not going to be what it described as being the gold standard on the environmental contamination, a covenant not to sue sometime in late fall of 2023. So notwithstanding though, the planning commission went ahead, steamrolled through, and approved a conditional use for an accessory gas station before it has any assurances about the principal use itself. The city of North Canton zoning code was overhauled and amended in 2021 and consistent with the city's master plan. North Canton prohibited gas stations in any of the 5 primary districts located in the city's central corridor. The city's land use planner was unfamiliar with the fact that the zoning code had been amended in 2021. He testified before the planning commission. Indeed, in 2019, before you guys even amended your zoning code, there was an ordinance that was passed by the Community and Economic Development Committee that recognized that more gas stations do not belong along Main Street when it passed resolution number 2-2019, a resolution requesting the planning commission consider recommending to city council restrictions on new gas station locations on Main Street to maintain and promote the aesthetic features of Main Street as a core area for retail sales and service. Specifically, a text and a map amendment were recommended. It was recommended that the planning commission place special emphasis on recognizing city council's concerns in providing appropriate and convenient locations for business activities while protecting residential neighborhoods from traffic and pedestrian congestion, noise, and other objectionable consequences. Nevertheless, on June 21st, 2022, City Council passed ordinance number 24-2022 to allow gasoline stations when accessory to a retail use as the primary use on 5 or more acres. And that was done specifically and singularly as an accommodation to Meyer and specifically for that development, not for the benefit of anyone else. The proposed conditional use does not comply with the spirit and intent of the newly amended zoning code effective 2021. And in fact, it ignores the time, energy, resources, and expertise that went into amending the zoning code 2021 to begin with. Now, I'm going to turn my attention briefly to the conditional use application. And again, it's described as being a conditional accessory use. Accessory is defined as being incidental to, not an intention of. And this clearly is not incidental to. It is a standalone gasoline station. The approval was illegal and invalid because, first of all, it was subject to a stay. Okay, so on August 30, when that was approved, there was a continuation of the original August 3rd hearing on the conditional use application. On August 3rd, the Planning Commission plowed ahead and passed and granted approval for a conditional use application, even though at the time there was pending an appeal of the development plan. Now, Mr. McLuth has submitted in papers to the Board of Zoning Appeals that these are entirely separate matters, right? But there were 5 conditions that were attached, 5 conditions that were attached to approval of the development plans, one of which was the approval of a conditional use application for the gas station. That it squarely ties the two together. And then when you took action, not you, but when the Planning Commission then took action on the gas station, it satisfied one of those conditions for the business development, for the development plan. It checked a box. It was in furtherance of that approval and that application, and it violated the state. It should have been in place based upon the appeal of the development plan. Again, the approval remains invalid because there's still not an approved principal use. You have to have a principal use before you can have an accessory use. There's a principal use that's been, a development plan that's been approved, but there are multiple conditions that are outstanding, not the least of which is the significant infrastructure improvements that are gonna have to be done on Main Street and the environmental remediation that's going to have to take place. You can't put the cart ahead of the horse. You need to get the principal use nailed down before you give approval for the conditional use accessory gas station. It fails to meet the requirements of the zoning code, the conditional use. The testimony that was offered by the city's witnesses is not substantial, it's not reliable, it's not probative, and it doesn't support the record below. Let's go through some examples of that just briefly. So the city called Sean Suter as their land use expert. Mr. Suter had no involvement in the 2022 amendment, wasn't even aware that the zoning code was amended in 2022. He didn't know if before 2022 gasoline stations were even permitted on Main Street. Didn't know. He said that he agreed with me that the pedestrian-friendly goals that are set forth in 1136, 01, and 02 apply to all the districts along Main Street, not just the corridor, the central corridor. He said that the only thing that he had reviewed in preparing his testimony that evening was 1136 itself. He hadn't even reviewed the preliminary plans. The city paraded in a bunch of witnesses that were unprepared, uninformed, and said presumably what the city wanted them to say, right? But this is true with respect to all of them, with the exception of maybe Mr. Smith, who's sitting here. I see him sitting here. Mr. Smith was an environmental expert that testified on August 30th, and he said he didn't have any idea about, from a monetary standpoint, how much it was going to cost, but he did mention he didn't expect getting a covenant not to sue until sometime in late 2023, somewhere around November, December timeframe. You had Kevin Westbrooks, who was your traffic expert, the city's traffic expert. He hadn't seen any specific plans to address the concerns that were set forth in his report. He testified that there was a 16% increase in traffic in the morning based upon the gas station alone, but was unable to give me any evidence or any testimony as to what the principal use, what the effect would be concerning traffic there. And then, this one was Bob Graham. I don't know, is Bob here this afternoon? It's not Bob. Bob Graham maybe was the most candid of the witnesses. And, when I asked Mr. Graham about, he was going to testify about the impact on the surrounding area, right? Because that's a factor that has to be considered in regard to conditional uses. I'm going to read verbatim what his testimony was, okay? And what his testimony was, this is the city's expert, okay? Okay, this is me, question, okay. This is found at page 333 of the transcript. Other than your general experience over the years, can you tell the Planning Commission what specific action you took in regard to market analysis of the surrounding areas, surrounding Meyer? Sure. Answer, sure. Fair question, none whatsoever. And to follow. But just so that I'm clear as far as this question, just so that I'm clear as far as actual analytics, as far as actually analyzing the economies and the surrounding properties and looking at the data, looking at the square footage, how it's leased, the revenues, that sort of thing. You haven't done any work, as far as I understand it, in terms of actually analyzing those properties. Is that fair? Answer, that's fair. These witnesses undermine, not only do they not advance the record, they undermine the record for the city. The applicants failed to provide that it is entitled to have its application approved. The record does not satisfy the requirements under 1145, either the general or the specific requirements. And for those reasons, and for the reasons that are already made known in the record, the Board of Zoning Appeals should reverse the Planning Commission's decisions in each of those actions. The conditional use and accessory approval should be reversed, and the principal use development plans should be reversed. Neither are supported by the record. Thank you.
Thank you very much.
Thank you, Mr. Chairman, and Majid Makluf for the city of North Canton. I know Meyer is here and would want to address the board, but I think in terms of the line of the opening statement that just happened, I may go first and then I'll turn it over to Meyer to speak. But I would urge the board to pay attention to the closing statement, to the very last paragraph, if you wish, of appellant's counsel opening statement. Picked on the testimony of Robert Graham about whether the city had done any analysis of the economies of the surrounding area. First of all, Rob Graham is the city engineer. The reason he was testifying before the planning commission is on the procedure that the city follows through to make sure that traffic impact studies are followed, that stormwater management issues are addressed, that any environmental issues are addressed. That was the purpose, and that is what Mr. Graham testified to. And because the city of North Canton has a unique procedure, the city of North Canton made a legislative decision that they wanted to segregate issues of engineering, issues of stormwater management to the administrative staff. So the procedure that works in North Canton, and it was consciously made as a decision to promote development in the city, that the questions, the big question, the general development plan. If you notice, North Canton uses the term general development plan. There are many other cities that have different terminology. They have a site plan, they have a preliminary site plan and a final site plan. North Canton consciously chose not to do that and to do a general development plan. And the big picture items go before the planning commission for approval. And the code is very specific that later there will be compliance with those issues that will be administered through the city staff, through Mr. Graham. And that is exactly why Mr. Graham was before the planning commission testifying, and that was the nature of his testimony. But I don't want to forget the point about
Majid, forgive me for interrupting you. I misspoke. It was not Mr. Graham, okay? It was, and I apologize for that. It was Mr. Snyder that was the appraiser, so I stand corrected.
Okay, and Mr. Snyder is not a city employee. Mr. Snyder is an outside appraiser who came in and gave his testimony to the planning commission. But I don't want to lose focus about this word economies, because that's really what all this is about. This is about a competitor worried about a competition coming across the street and is trying to misuse the city's zoning processes and procedures to interfere with the contractual relationship between the city and Meyer and to thwart competition. Elimination of competition is not a proper function of government. It is not the role of the city of Canton. It is not the role of the planning commission. And it is not the role of this board to pick winners and losers in the free marketplace. That is for the marketplace to make its choice. And I think this appeal that we have and all this complaints about hurriedness and speed and rush, I think you will know and you will hear testimony that this is the typical process that happens in North Canton, and nothing happened here out of the ordinary that doesn't happen anywhere else. I want to address the other issue pertaining to the appeal before this board, because this hearing is not what I want it to be. It's not what Mr. Swing wants it to be. This hearing is what the city code provides it's supposed to be. And if you look to the city code, it specifically provides that when there is an appeal, it is set for a public hearing. And there's a difference in the law between a public hearing and a public meeting. A public hearing is a forum where you have the introduction of evidence, where you hear testimony. So the idea that we are trying to restrict the appeal before this board as if it's verbatim looking at the transcript as it was before the planning commission and sits here just based on oral argument and affirms or reverses, that belies your code. That belies the express language of your code. And we are, doesn't matter whether I like it or he likes it, that's what the code provides. And if you look to section 1179.06 of the city code as to the review on appeal, of the appeal, it says the Zoning and Building Standards Board of Appeals shall review the appeal. To aid in their review, the board may transmit the application to appropriate administrative departments and professional consultants for review and comment. Any reports, comments, or expert opinions shall be compiled by the Department of Development Services and presented to the board prior to the time of the board's review. So not only do your regulations allow the parties to have a public hearing in which they introduce testimony, it allows the board itself to request additional expert testimony and opinions and to be compiled for the board's use for the hearing. That is the city code. Now, with respect to the roles and deferences, I think that Mr. Swing goes into that the city has given to Meyer, and I think even previously in some of the letters, he has complained about my role, my position here, arguing before the board or before the planning commission. I have been doing land use and zoning law for 20 plus years. And I know that typically a retailer like Meyer, when they go before cities, they consciously choose not to have legal counsel. Because the idea they don't want to force themselves into communities. They come in, they bring their individuals, which you have them here today. You have the design professional, and you have Mr. Chris Jones who are senior real estate officials who are equipped and empowered to make decisions on behalf of the company. But they go into a community not wanting to come in with threats, not wanting to come in with dictating to the community what they want to do. They come to the community and they say, this is what we have to offer. We hope you like it. We want to collaborate with you. We want to approve it. So almost never would you have a retailer like Meyer or Menard go in a community with legal counsel. The city here, and it's always, to distinguish between the role of the applicant and the role of the city. The city always has a vested interest in any application that goes before the planning commission. At core is the interpretation of the city's zoning code. So the city has a vested interest to participate in the hearing and to make sure that its voice is heard. In this case, the city also owns the property. It is the property owner. It owns it through its Community Improvement Corporation. So it has every right to appear and present testimony and evidence. And they chose to take advantage of that in this case. It's very clear to the Planning Commission, and it's very clear to this board, that the Planning Commission is an independent body. And it's very clear that this board is an independent body. This board makes its own decision. I think the chairman gave the instructions to the board at the very beginning in terms of you vote your own conscience, you vote your own, based on the evidence that is in front of you. The city appears before you like any other party. And that is the way that this develops and this proceeds. So the idea that somehow, quite frankly, if I know he hasn't said it directly, but implied in every way possible, that somehow that the cake is baked here. If the cake were baked, the city wouldn't have gone out of its way to hire legal counsel, to put an entire case before the planning commission, or to even hire legal counsel to be here and make a presentation before the Board of Zoning Appeals. The very fact that the city is investing so much to make a case before the board demonstrates the independence and integrity of this board and the independence and integrity of the planning commission. Now, with respect to the testimony that happened before the planning commission, there's no requirement in the code about any testimony. The idea we keep talking about the appellant bearing its burden. Yes, the appellant has a burden, but there is no requirement that that be made through testimony, through witnesses, through often, sometimes in smaller cases, the applicant is told you may choose to come or you may not choose not to come. The planning commission will review the application, will review the plans, and will make a decision based on the application of the plans that are submitted. But we keep portraying this, and Mr. Swing repeatedly portrays this as if Meyer did nothing. Meyer submitted the application. Meyer appeared before the planning commission, explained the application, explained the project, answered every question that was presented to you. And that's the record. You have the transcripts from what happened before the planning commission. And the way that it happened is, I think Mr. Swing didn't wait for the city to put its evidence forth. Started going through with the cross-examination and with the appellant's case before the city had a chance to put its case base before the planning commission. So the way that it worked, and he was accommodated. So the way that it worked is the city ended up putting on its case after he had rested with his case, but that was his choice, that he immediately delved into the opponent's case without letting the applicant and the city finish the case before the planning commission. But let's talk about the witnesses that the opponent before the planning commission. The opponent brought an architect from Lakewood who has not visited the site, who is very unfamiliar with Stark County, and whose sole experience in the zoning area, having served on the planning commission of the city of Bay Village. I had the pleasure in my years of having served on the planning commission of Bay Village, so I'm very familiar with Bay Village quite well. And it is a city that is 100% developed on the lake, that very much is not in favor of commercial development or any type of development in the city outside of a very limited area, and the entire city is residential. It has one of the highest real estate taxes in the state, and people willingly and happily pay that because they want it to be completely residential. That is not the choice that North Canton made. North Canton made the choice, the city council, the legislative, the elected representatives of the city, made a different choice. Made a choice that they wanted to be a pro-development jurisdiction. Made a choice to invest in economic development. And so the testimony from this architect that basically was trying to argue, again, we're stuck on this pedestrian issue. I'll explain to you in a second, and you'll hear testimony from Mr. Marty Van Gundy, and you'll hear testimony from land use planner who's a professor at Cleveland State University on this pedestrian issue and the applicability on the Gateway District. But that was the crux of his testimony is that this is not pedestrian friendly and made a big issue that the gas station is on a separate parcel because the consolidation was a condition of the approval as opposed to being done before the approval. And the testimony before the planning commission, and Mr. Suter testified to this, and you will hear it again tonight. It is very typical to make lot consolidations a condition of approval. This is the standard practice. Because if you think of your traditional development, the developer goes in and has to assemble the site. And there are often multiple property owners. You buy different properties, you consolidate them into one parcel for your development. No developer will close on any such purchase before they have all their zoning approvals in place. And you cannot consolidate the parcels unless you have unitary ownership. So the idea that lot consolidation is a condition of approval is a standard condition almost in any zoning approval that happens. That is what happened here. Nothing out of the ordinary. That was the testimony of the great expert. The second expert that they had before the planning commission was a land use planner from CT Consultants. CT Consultants was actually consulting for the city on this very same project. The conflict of interest was screaming beyond any, I'm out of words. The amount of preparation that witness made failed to do the most basic due diligence to check whether her own firm is working on the very project that she came to testify against. Shows you how prepared she was for the role that she was willing to testify before the board. And again, she basically repeated the same thing that the architect had said before her. And it honestly was unfair to her to put her in the stand for legal counsel to force her to testify after the objection was made. And what that prompted is it prompted her employer to submit a letter to the planning commission to withdraw her testimony because of the conflict of interest.
Objection. She did not state in that letter that she was withdrawing her testimony. So let's choose our words carefully.
If I may approach. So it prompted that letter, and the letter speaks for itself. The board is just as capable of reading it as me describing it for you. To the board about her testimony before the planning commission. I want to address this other issue, which is this purchase and sale agreement between the city and Meyer. And for a second, if you would pause and think about it, we are here about zoning approvals. Zoning approvals. The terms of an agreement for the purchase and sale of property, whether that purchase and sale agreement was between the city of the property owner and Meyer or a farmer, are completely irrelevant to the questions before the planning commission and before the board of zoning appeals. Those terms are proprietary. They haven't closed on the deal. What if the deal falls through and the city wants to put the property again to sell it? That purchase price, whatever it is, could be used against the city. If Acme wants to purchase the property, it shouldn't have the benefit of knowing what the terms of that agreement are. It should make its own good faith offer to try to purchase the property, not try to improperly get the terms of a purchase and sale agreement that has nothing to do with the zoning approvals before the city. Now, Mr. Swing went into this issue of stay before the planning. There were two separate approvals before the planning commission. One was for the general development plan, and one was for the conditional use. They chose to appeal the general development plan. They don't get to stay the appeal. They don't get to stay the consideration of the planning commission of the conditional use. It specifically says, the 1179.05 says that the state stops all proceedings in furtherance of the action appealed from. The conditional use is a separate action. And just because the approval was a condition of approval does not make it in furtherance of that action. That would be in furtherance of the action, that would be building permits. That would be construction approvals. That is not what happened here. I know we have submitted before the board proposed conclusions of fact for both the general development plan and for the conditional use. And I hope that the board has had a chance to review them, and they are separate. But I will quickly just summarize some of the conclusions of fact. And I think once the testimony is finished and when we go into the closing arguments, we'll go much more in depth into some of those issues.
Mr. McClure, did you provide copies of those to Mr. Swing?
Yes, he was copied on the transmission.
Okay, I just wanted to make sure.
Yes, sir.
Okay. Thank you.
Yes, no, everything I do, he's copied. The general development plan, again, when you look at the city code, it requires items to be submitted for consideration. Those items were all submitted. The city's professional staff reviewed them and determined that the application is complete. That's how it made its way to the planning commission. Mr. Swing wants to complain about a traffic impact study. There is no requirement for a traffic impact study before the planning commission. Stormwater management plan. There is no requirement for a stormwater management plan before the planning commission. Wetland delineation study. There is no requirement for wetland delineation study before the planning commission. Again, if you remember when I started, the role of the planning commission in North Canton is to have the big picture approval, and all those things are followed on and approved separately later by the administrative staff, and that is precisely what Mr. Robert Graham was testifying about before the planning commission. The walkability issue, again, I don't want to get ahead of Mr. Soltis, who will testify on the walkability issue. But I think if you look to the zoning code, one does not have to be a professor at Cleveland State who teaches land use planning to understand this on their own. Just look at the permitted uses as a matter of right. The Northway district and the Gateway district versus the downtown. Retail permitted as a matter of right. Business equipment and supplies sales are permitted as a matter of right. Hospitals permitted as a matter of right. Office warehouse and storage permitted as a matter of right. Distribution, warehouse, and wholesale outlets permitted as a matter of right. New car sales permitted as a matter of right. Sports and fitness centers permitted as a matter of right. Clubs, lodges, assembly halls permitted as a matter of right. in the North Gateway District. The idea that this district is envisioned to be this microcosm of a downtown area belies common sense. The code says that you respect the districts in which you're located. And in this district, this is the exact use. Whether it's across the street from Acme, it fits perfectly in the uses where it's located. The appellant has gone to the point in some of the briefing that was submitted to the Planning Commission of showing a picture, an illustrative picture in the zoning code that's looks almost like Crocker Park or Legacy Village for those of you familiar with it, which was intended, when you look at it, it very much looks like a downtown central cozy picture to say that this is how the development here should look. That's the absurdity to which we've gone to try to thwart private competition. That is an improper use of government functions. Again, these environmental issues, the record is very clear. Mr. Smith testified that all those environmental issues are being addressed. And the date of the covenant not to sue or the no further action letter that Meyer will get from the Ohio EPA. Environmental issues are the province of the EPA. They're not the province of the city. The city has no jurisdiction over those issues. And when they get that date, they don't have to wait to start operations until they get those dates. They do the remediation. That date, the covenant not to sue, or the no further action letter, that is a liability protection to Meyer from being sued by the EPA over environmental issues. That has nothing to do with the construction on the site and when that can happen. I think, as you will hear from Meyer, with us getting around the Indiana bat period when you can't cut trees and things of that nature, time is of the essence on this project. And any delay, as Mr. Swing wants you to do, is just to continue, is to kill a project by delay, is I think what we've gone to. Now, when we talk about the conditional use, and again, there is the separate conclusion of fact that we submitted to the board on the conditional use. Mr. Swing makes big issue of the Planning Commission having placed conditions on the approval. That is a difficult procedure. And your zoning code expressly provides that the Planning Commission may place conditions on the approval. In section 1145.03, it expressly provides that the Planning Commission places supplementary conditions on these and safeguards on the conditional use approval. And that was something that the Planning Commission was very familiar with. I still remember vividly, before the Planning Commission voted, the chairman went through the criteria for the conditional use approval one by one. Every single criterion went through them one by one before the Planning Commission. And also read section 1145.03 pertaining to the conditional uses of the authority of the Planning Commission to place conditional uses. This was far from hurried. This was a Planning Commission who knew very well what it was doing. And honestly, if you think what the Planning Commission does or what a Board of Zoning Appeals does, it's volunteer citizens serving their community, coming there and taking away their time to serve their community and do their duty and do their jobs. It's quite offensive to sit here and attack them as if they're just rushing, just trying to rush through this to do a private favor to Meyer, as if there's anything in it for them to help Meyer or any. These are civic-oriented citizens who sit on these boards, and we should thank them for their work instead of attack them. The issue about the conditional use being only to multifamily, and again, if you read the code and we explain it in the proposed conclusion of fact, they confuse structures with uses. The prohibition on the accessory uses is for structures in section 1136.10. but city council specifically allowed gasoline stations as accessory uses for retail that sits on 5 acres or more. And quite frankly, even if he were to be right, she's not, but even if he were to be right, the law in Ohio is crystal clear. The Supreme Court has told us that zoning regulations are in derogation of property owners' constitutional rights. And if there is a conflict, you have a duty, and the court has a duty, to interpret it in favor of the property owner to allow the development. Because you are taking away a property owner's constitutional right, the prohibition has to be unequivocal. There has to be no question about it whatsoever. And that is not the case in the zoning code. It's the confusion of the structures versus the uses, and there is a specific allowance for the accessory use. But again, this is the second time that I sit through these hearings, and I sort of have to scratch my head, what hearing am I at? Because the appellant seems to have an issue with the city council amending the zoning ordinance to allow gasoline stations as an accessory use. That is a legislative function. That is not a quasi-judicial function or administrative function. That was a legislative decision that was made by the city's elected leaders to change the zoning code. You can't come before the planning commission because you don't like the zoning code as it's been amended. You come before the planning commission, and if the planning commission disagrees, come before the Board of Zoning Appeals and say, stop it because I don't like the amendment to the zoning code that the city council did. That's effectively the argument that you have in front of you. Not only that, Acme has had its chance to go before the city council and make its case to the city council why they do not want the zoning code to be amended. And I may approach.
Yeah.
Thank you. And you will have in front of you the testimony of Mr. Swing. I don't know if it was understood. The argument of Mr. Swing before the city council, asking the city council not to amend the zoning code on June 13th, 2022. And the council chose to go ahead and do the amendment. You will hear from Mr. Van Gundy. The zoning amendment we keep talking about as if it was done in the dark of night. It took 8 meetings, including 2 meetings of the planning commission and 2 public hearings. A public hearing open to the public before, all the meetings were open to the public, but a public hearing before the city council and a public hearing before the planning commission, before they went through this hurried amendment that they were just rushing through to help Meyer get it through. So facts do matter. It's not the way we can always take snippets of things and try to change them, but the record speaks for itself. And I talk too much, so I'm going to sit down. I would just submit that, and you'll hear testimony that the evidence is overwhelming. You should affirm the Planning Commission's approval of the General Development Plan. We ask you to adopt conclusions of fact in so doing. And that you should also affirm the conditional use grant. We ask you to adopt conclusions of fact when you do that. We've submitted proposed conclusions of fact. Those are purely for your review. They're not, the Planning Commission chooses what it wants to do in terms of what facts you can reject them, accept them, do whatever you want with them. Those are purely suggestions there for the planning commission. We do plan to put on evidence before the planning commission, but before I do that, obviously, I know these are the opening statements, and I don't know if Meyer would like to speak, so I would sit down and ask. We'll come back for evidence and hopefully closing on. Thank you.
Okay,
Hollinger,
yes.
did you say that you would permit me an opportunity for rebuttal?
Yeah, now, let's think about how we're gonna do this, though, because now we've given opening statements. I've got Meyer, who's the applicant, so if they want to say something, I'm gonna give them an opportunity to say something. And then, we'll do witnesses.
We're not presenting any new evidence or testimony this evening.
Okay.
We're bound by the record below,
Okay,
but I would like an opportunity to correct some very serious and very, that there are a fair number of misstatements that were included in that.
okay.
And I would like an opportunity to address them while it's fresh in everybody's mind.
Let me have Meyer speak first if a representative from Meyer wants to speak. Go ahead and say your name at the podium, and then Mr. Swing, after he's done, I'll give you the opportunity to do that.
Thank you.
Good afternoon. My name is Chris Jones. I'm with Meyer Real Estate Department, Senior Real Estate Manager. I've been in the development business for about 30 years, and I just wanted to touch on a couple of things that Machine said that I believe are really critically important to this, what's before you this afternoon. And that is that he touched on that this land is permitted by right to be used for retail purposes. And I think that speaks really volumes as to this case in front of us. We have the right to develop the property for a retail project. The second thing he touched on was the conditions. Well, what he touched on was Meyer's application with the planning commission. We submitted an application, we paid our fees, we submitted it compliant with the city's requirements. We checked all the boxes, all the information that's required to submit an application was submitted. And it's evident of that by the fact that they scheduled a planning commission for the land use and the planning commission, and they heard our presentation. So in the contrast to that, if our application was not complete, we would have had to make sure it was compliant. Our application met the city's requirements to be here. And I think those are the two things that I picked up on Regine's that I just wanted to reemphasize. And I'm happy to answer questions, and thank you very much for participating in this process.
Does anybody have any questions for you? Okay, at this time, Mr. Swing, go ahead if you'd like to do a quick rebuttal, and then we'll get into whatever testimony the parties want to, or evidence that the parties want to introduce.
Thank you, Mr. Zollinger. May it please the board. I appreciate the civic duty that each of you perform, and I respect and appreciate the civic duty that each of the planning commissioners perform. I'm not going to apologize for Albrecht's right as a landowner, as somebody who has paid significant taxes over the years and provided a great number of families dinner on their tables, for insisting that the zoning code be applied and enforced as it should be, and that there be an orderly development of the city, if indeed is a resident also. This sort of veiled threat about interfering with a contract, I find interesting, particularly where I've never even seen a copy of the contract. And when they talk about how much the purchase price is and not wanting to show its hand to Albrecht, there have been public statements about what the city paid for the property. So unless there's some discrepancy between what's in the purchase agreement and what's been said publicly, I'm not sure what the big secret is. This point about adjudication hearing versus a meeting, take a look at the agenda for tonight. Does it say, and if you look at the agenda for the conditional use, accessory use hearing, it said adjudication hearing, it specifically said that on the item. It doesn't say that this evening. It says meeting. This is an administrative process, and I'm not I don't take any joy in coming to the city of North Canton and being disruptive for disruption's sake. An applicant has to meet its burden, not the burden to satisfy the requirements for submission of an application, but it has to present evidence to support the actual application that's being sought. In this case, there are two things. As the nice gentleman from Meyer mentioned, okay, the city abruptly rezoned that to be a conditional, or excuse me, to be a permitted use, the principal use, the Meyer Super Center. The gas station is a conditionally permitted use. And let's not conflate the terms here, okay? Conditionally permitted use, okay, I'm gonna allow you to operate a bar, but it's gonna be between these hours and there's gonna be no music. Those are conditions. Those are the types of conditions that we attach to a conditionally permitted use. Saying that I approve the development plan subject to, I need a stormwater plan, I need a wetland delineation, that's an entirely different animal altogether. And so the conditions that we're talking about, we're not hours of operation, which by the way, the testimony was that they wanted to operate 24 hours a day, 7 days a week, which would violate your zoning code. So it's not about the economics. Albrecht, as a longstanding property owner, has the right, it has standing, it received notice of an adjudication hearing, and it appeared, and it presented its arguments as to why the condition, why the Meyer should not be approved. There are a lot of things here. I'm gonna go through them as best I can. Nowhere does it say, Mr. McLuhan's point, that the Board of Zoning Appeals is entitled to receive and hear additional evidence. Indeed, you're allowed to put yourselves and you're allowed to step in the shoes of the Planning Commission with respect to the record that the Planning Commission reviewed, and to exercise the same rights that the Planning Commission could have exercised. But you don't have the right to back and fill the record with new evidence at each and every opportunity. What's really interesting is when they try and characterize the city as accommodating me on August 3rd by allowing me to present, that the city was flat-footed, caught flat-footed on August 3rd. They didn't expect anybody to show up with witnesses that would testify about land use, about the other items that you all heard about that are already in the record, okay? They got caught flat-footed. They didn't have anybody to present evidence for, and you know what? So while Mr. McLuhan may be correct that the city's not required to present testimony, the applicant there has to be a preponderance of the substantial, reliable, and credible evidence on the record as a whole to support the decision that's been made, and I respectfully submit to you that it's not happened here. Let's try and go through these. Okay. The conflict of interest point with the land use expert that gave testimony on August 3rd. Nowhere in that letter does it say she's withdrawing her testimony. I keep hearing that that evidence has been withdrawn. That evidence is part of the record, and that evidence was credible and reliable. In fact, that evidence came from an expert that the city apparently uses in its own right. So I don't know why the city would question the credibility of that expert. There's been no evidence in the record that she had anything to do with, or frankly, that CT Consultants had anything to do with this specific project. That evidence doesn't exist. It's not in the record, okay? Were they working on unrelated matters? Perhaps, I don't know. Council would rely on the expert to check and run those conflicts. But there's no evidence in the record that CT Consultants had anything to do with this specific project. Reading code provisions, standing up and reading code provisions, that doesn't constitute evidence. So on August 3rd, with regard to the development plans, when Meyer representatives stood before the Planning Commission and simply read one item after the next, okay, in the zoning code, that's not evidence. That's just somebody reading the provisions in the code. There was no evidence that was submitted that would prove that those elements or requirements were being satisfied. The issue on the, very dangerous, right? The issue of the contamination, okay? That we would think that we could commence construction on a site that has the degree of environmental contamination that this site has without there being some type of a remediation plan in place first, is curious. I don't know how they plan to disturb the area before they get appropriate clearances through the OEPA. And even the wetland delineation study that was, again, prepared and provided after the fact, I shouldn't say prepared after the fact, it was provided to me after the fact, after the planning commission meeting on August 3rd. Even the wetland delineation study said it was incomplete because they couldn't disturb certain of the areas because there was environmental contamination. I would submit to you that, you know, the gas station, whether it's a use or a structure, it's accessory. It's not accessory. It's not incidental to. And whether it is a use or a structure, it still violates the zoning code in as much as it has nothing to do with residential in that zoning district. I appreciate the patience that has been afforded me. I thank you for listening and hearing Albrecht out. Albrecht has been a longstanding resident and has every right, and not to be apologetic, to state its views about how the city continues forward with the orderly development. But this, I would submit to you, is being done for reasons that are contrary to the spirit and intent of the zoning code, contrary to the spirit and intent of the amendments that were done in 2021, and frankly, irregular procedurally and otherwise. And for those reasons, I think you ought to reverse what the planning commission's done and go back to square one, respectfully. Thank you.
Thank you, sir. Mr. Swing, you have no witnesses or evidence you're going to submit, is that correct?
No, but we will rely on, with regard to the conditional accessory use appeal, with regard to the record that's been established already for that. Same thing with respect to the preliminary and final approval of the development plan. Thank you.
Duly noted, thank you. Mr. McLuhan.
Thank you, Mr. Chairman. I need to start with an apology. The rush of speaking, I gave you the wrong exhibit when I talked about the June 13th, 2022 meeting of the city council, in which Mr. Swing appeared and spoke against the rezoning. I gave you the wrong exhibit. This is the correct exhibit, if I may. We will need that exhibit for Mr. Van Gundy's testimony, so if you keep it, but this is
Okay.
the correct exhibit.
Oh, this.
Thank you.
Whenever the board is ready, we'll call Mr. Marty Van Gundy.
Yeah, now it's my understanding Mr. Van Gundy is going to sit here and testify. Is everybody okay with that? Mr. Sling, are you okay if he just stands here, sits here? Okay,
Yep.
all right. All right, yeah, go ahead. You can proceed when you're ready.
The witness, please.
Just make sure you keep your voice up. You solemnly swear that the testimony you're about to give will be the truth, and the truth, and nothing but the truth.
I do.
Thank you.
Mr. Van Gundy, I know the board knows who we are, but if you could quickly identify yourself for the record, your position, who you are and your position.
Martin Van Gundy, Director of Development Services, also Chief Building Official.
Mr. Van Gundy, you've heard us speak repeatedly about the rezoning process that happened in 2022 for the addition of the gas station accessory use to retail 5 acres or more. Can you briefly explain to the board how that process happened, what the city went through, and how many meetings that involved?
Absolutely. There was a total of 7 public meetings held for that amendment. The first one was March 7th of 2022. That was the first consideration at the Committee of the Whole. April 6th, 2022, a public hearing before Planning Commission was held. April 18th, actually all these dates are 2022, so I'll refrain from reciting that each time. But on April 18th, the second consideration at the Committee of the Whole. May 23rd was a public hearing before City Council. Also on May 23rd was the first reading of the ordinance. June 13th was the second reading. June 21st was the third and final reading. And July 22nd was the effective date.
Did the council waive any rules in the adoption of the rezoning?
No,
They followed this traditional process for any legislative text amendment that the council does?
they did.
Mr. Begun, if you would go to the zoning code, if I may direct you to section 1136.01.
Okay.
That says that it's the intent of the Main Street district. If you could please quickly read it for the board and explain your understanding of what that intent provision stands for.
Would you like me to read parent A?
A, probably from where it starts, these districts are established.
These districts are established to promote the development of a higher density, more consistent, walkable urban fabric and attract increased investment in key commercial corridors and nodes. The Main Street districts are intended to respect existing surrounding development patterns while promoting desired development patterns within each district.
So if we would stop there for a second, when it talks about districts, what does it mean by districts?
Well, the Main Street, this ordinance in particular was separated into 5 distinct districts. The Main Street North Gateway, the Main Street North, Main Street Center, Main Street South, the Main Street South Gateway. Each one of those have a very distinct pattern about each portions of that section along Main Street. And I'd like, even as this progress through the legislative process, I think that last sentence really does pull out much of what this ordinance revolved around. And that is, the Main Street districts are intended to respect existing surrounding development patterns while promoting desired development patterns within each district. So, as we talked about previously at the Planning Commission on record, the Main Street Center is a much more dense, walkable portion of the town, the core of the city. As you move north and south, it becomes less so. Particularly, this project obviously is located in the Main Street North Gateway. The Main Street North Gateway has much larger blocks. It not as walkable as, say, the downtown, where you have a common parking area. The north, there's very large parking areas, larger retail establishments, and much more auto-centric as opposed to the Main Street Center.
And that is what meant by respecting existing surrounding development patterns within each district on its own.
Exactly.
If I may direct you to section 1136.06B.
Okay.
If you could explain what the section is to the board, please.
Are we looking at figure 113606B,
I'm sorry, 1136.06A.
A? Okay. 113606A is the schedule of building setbacks. So here, again, this furthers on what I just mentioned on the intent. If you look particularly at the North Gateway, our front yard setback is, the minimum is 0. Where you see on the maximum, there is no maximum. It's not applicable. Where you get into the center, for example, both of those figures are 0. So obviously they're wanting the buildings to be at the front property line, which is typical for your walkable downtown. moving on to the minimum side yard setback is 10 foot. And again, getting to the maximum side yard setback is not applicable. Again, no maximum. It can be as far away as the developer, sees fit for their development. And then the rear yard setback, again, does not have a maximum. It has the minimum.
Okay, how does that compare to the central?
So again, on the central for the side yard setback, there is zero. They're wanting that built up against the property lines. That's a much more dense development, where in the North Gateway, again, having that no maximum, theoretically, the building could be, all the way in the back of the parcel and nowhere near any other adjacent developments.
So when the code talks about walkable districts, could you accomplish identical walkable districts between Central with these setbacks and the North Gateway with no maximum setback whatsoever?
Yeah, so having the 0, 0 is going to create a much different walkability effort to it, as opposed to the options that the North Gateway offers. With an automobile centric zoning district, it's expected most of the patrons, or a majority of them anyway, will be in the automobile, and the walkability portion is not much of a concern as it is the vision and intent for the downtown.
Mr. Van Gundy, you've heard quite a bit of the argument about how things were hurried and apparently special favors made to Meyer here. Have you done anything differently on this application than you would have done on any other application before the city?
No, we followed all the procedures as we typically would, and as far back as I can tell, the procedures, the conditions, all of that is very similar as far back as I can see in the city records as well, which I think we'll talk about.
If I may hand an exhibit to the witness. This is the exhibit that I gave you by mistake the first time. You have, I think the board has it. It's
Yeah, just for the record, I'm gonna object to the exhibit. It's something from 2002, which was 20 years ago, and has zero relevance to the proceeding this evening, but without objection.
Okay, your objection is noted. I don't know if we need to vote on all of these objections, what the council wants to do. I would note the objection for the record, and then we'll let the board members make their own decision whether they want to consider it as evidence or not. That's okay.
Mr. Zollner, that's fine. I just want to make the record. Thank you
Okay.
for allowing me to do so.
No problem. Okay, go ahead, proceed.
Mr. Van Gundy, do you recognize this exhibit?
I do.
Can you describe it to the board?
This exhibit is action that the the property owner across the street, the Acme, the Albrecht development, was seeking a gas station on their parcel.
On their parcel, seeking gas station on the Acme parcel.
On the Acme parcel, correct.
And let's go, there is the minutes of the meeting, and then after the minutes of the meeting, there is the application. Who submitted the application?
The application was prepared by and submitted by Crumroy Construction Company.
So an agent for Acme submitted the application, not Acme itself,
Correct.
which is the same thing here as Wilpert submitting the application as opposed to Meyer itself as the property owner or developer, right?
Correct.
What did they seek in this app?
In this application, the zoning that existed before any action they initiated did not permit the gas stations. So they were seeking a zoning amendment from GBA to GBB, which would permit the gas station. In addition to that, they had submitted a site plan for the general development review.
And do you know if the general development plan was approved?
The general development plan was approved with two main conditions.
If we can go to the first page of the application that shows the checklist and record of applications.
There's where we will find the two main conditions. The first one was council must approve the rezoning for the lot before construction can begin. The second one was the parking lot dimensions are to be revised and approved by the city engineer.
So when it came to Acme's side, they even approved the general development plan without even the zoning being in place at the time, correct?
Correct.
So we're not even talking about simple lot consolidation. The actual zoning to permit the use was not in existence.
Right.
And also, there was another condition regarding the engineering issues, the parking, things of that nature, that have to be approved by the city engineer.
Right.
Was there anything improper about doing that?
As I mentioned, that was consistent with the city code and the procedures, you know, as far back as I found records.
And has that procedure of placing conditions changed since then and granting approval subject to conditions?
No.
Did Acme submit any traffic impact study in connection with that application?
I did not see one in the record.
Did Acme submit any environmental reports in connection with that application?
I did not find an environmental report as well either.
Did Acme submit any wetland delineation reports in connection with that application?
I did not find a wetland delineation report. However, I did see on sheet C103, which is part of this exhibit, does state limits of observed surface wetland type vegetation area. Total limits of any regulatory wetland boundary must be determined from a federal wetland study. So the wetlands evidently were present.
But they have not been determined by the Army Corps at the time,
Correct.
and the application was granted before the wetland delineation having been completed.
Correct.
How about any stormwater management plans? Were there any submitted to the planning commission for the approval of the general development plan?
I did not locate any.
How about in the case of Meyer? Do we actually now have a wetland delineation report with the city?
We do.
Do we have a traffic impact study with the city?
We do.
Do we have a stormwater management plan with the city?
We do.
Do we have any assurances as to environmental work that Meyer is doing on the project?
We do.
I'm sorry, what was your answer, sir?
We do.
Thank you.
If I may direct your attention to section 1175.05 of the zoning code, please. You can describe to the board what that section of the code provides.
Section 1175.05 is the development plan submission requirements. This is what we measure each of the applications before we send it to planning commission.
And did Meyer submit all of the required items?
They did.
And were you satisfied that the application was complete to submit it to the planning commission?
I was, and quite frankly, I would not have sent it to planning commission if I wasn't.
Does the city code require the submission of a traffic impact study, a stormwater management plan, or a wetland delineation as part of the zoning approval process?
No.
And how does the city of North Canton handle those approvals?
The code primarily relies on subject matter experts. So the code wants to make sure that they're addressed. but it's the subject matter experts that review that. And will produce any of the information needed for the proceeding as it applies to the particular project or application. Not all applications require the same level of information.
So who are, for instance, for traffic impact study, who is the authority in charge of reviewing and approving traffic impact studies and traffic issues?
The city engineer takes the lead on the traffic impact study.
How about stormwater management?
That is a combined effort between the city engineer as well as Stark Soil and Water.
I understand that the conditions that were attached here with the approvals were recommended by you, correct?
Correct.
Are any of the conditions that were attached either to the general development plan or the conditional use out of the ordinance?
No.
Thank you very much. I turn over the wheel.
Mr. Swing.
Thank you. Mr. Van Gundy, the development plan was approved on August 3rd, 2022, is that correct?
That is.
Preliminary and final approval of the development plan was made that evening, correct?
There's no reference. There's not a requirement for the preliminary or final, so I'm not sure.
That's not my question. My question is whether or not the planning commission approved preliminarily and finally the development plan for the principal use on August 3rd, 2022.
Objection.
It's the final. Excuse me. It's the general development plan was approved.
Okay, thank you. And at that time, was there a traffic study presented on August 3rd, 2022 when that approval was made?
Not to planning commission.
Okay. And was there a wetland delineation study provided to the planning commission on or before August 3rd, 2022?
Not to my knowledge.
Okay.
Excuse me.
How about any kind of remediation guide or recommendations with respect to the extreme contamination at the site?
Not that I'm aware of.
So those subject matter experts that you referred to, none of those were available and none of those provided any testimony on August 3rd, 2022 when the development plan was approved. Is that right?
Right.
Mr. Maklouf mentioned the public readings on the amended legislation, and I'm not sure why he's asking about
I'm
it.
sorry, can you say
Yeah,
that again?
forgive me, I'll slow down. Do you recall whether, with regard to any of those public readings, Mr. Van Gundy, there was ever any statement made by the city or by its city council that tied the ordinance to the orderly development of the city?
I'm not sure what you're asking.
Was there any reference made either in the legislation itself during the public reading that somehow attempted to explain or to tie together why the ordinance would further the master code or the orderly development of the city?
I wasn't at each of those meetings, so
So you're not able to testify that that ever happened?
I could not, no.
Okay. Notwithstanding the attempts to sort of distinguish between the corridor and the north gateway and the south gateway, the city's own expert testified that 1136 and the provisions specifically with regard to pedestrian-friendly environment applied to all the districts. It didn't exclude the north gateway, it didn't exclude the south gateway. Okay, it applies to all of them. And this development does not promote that, and it does not encourage that.
Objection. I'm not sure whether this is argument or question of the witness.
Okay, so Mr. McClure, you had your chance.
Well, Mr. Swing, if you could just like make sure you direct questions to, I'll give you a chance to do a closing argument and make points, but make sure you're asking questions, not testifying.
With all due respect, I'm not testifying. The attempts to augment the record, and that's what's happened throughout these proceedings. It's been hurried, it's been haphazard, and it's been by the seat of the pants, because going back to August 3rd, when the planning commission very first considered this, the city didn't have its ducks lined up, okay? And we presented testimony at that hearing, and the city should have tabled the approval of the development plan, but it didn't. It went ahead and approved it anyways, okay? And so it was our right to appeal it at that point, and that's what we did. The issue with regard to the condition and whether or not it was stayed, that development plan clearly had attached as a condition the approval of a conditional use for the Meyer gas station, which is an entirely different species than a permitted use. And when the planning commission went ahead and took action on that condition, it furthered the development plan approval process. I'll just end with this, if I may. What happened 20 years ago with Albrecht
Just
is,
for the record, we have more witnesses.
All right, do you have any more questions for
I don't have any
Mr.?
more questions for him. I
Van
don't
Gundy?
know if he thinks we're done. That's why I'm trying to.
Yeah,
clarify. I don't mean to interrupt.
well, I thought you were still cross-examining him. Are you done?
well, okay, let me get the question. Mr. Van Gundy, the fact that the city's always done it that way, right? The city has an obligation to follow its own zoning code. You agree with that, right?
I do.
Without regard to what its custom may have been over a period of time.
Correct.
It has to follow the zoning code.
Right. But it's an example of being development friendly, and that goes back as far back. That's consistent with the code. The code's been there. Many of these provisions have been there more than 20 years plus on that. The city's goal is to be development friendly, to promote development, and this is consistent with that.
Let me ask you something. If an applicant came to the planning commission and said, hey, don't worry, we're gonna satisfy all the general conditions for a conditional use. We're gonna do it at some indeterminate point in the future, but we're gonna satisfy all those. Is that sufficient evidence in your view to support the record for an approval of a development plan?
That's not what's happened here.
That's not my question. The record will speak for itself in terms of what's happened here. My question is, would that be sufficient in your estimation for the planning commission to approve a development plan simply because the applicant says, I will at some indeterminate point in the future satisfy these conditions?
It depends on the context of the project and the context of those statements.
Are you telling me that you can ignore the actual requirements in the code that show that the applicant has to establish that its project is going to comply with those various requirements?
No, it sounds like you're asking me to speculate, and I can't speculate on a project that doesn't exist.
I'm not asking you to speculate. I'm asking you whether or not the applicant has a burden to come forward with some evidence to actually support that those requirements are being satisfied, not just a promise that it's going to do so at some indeterminate point in the future.
And this applicant has.
Okay, and the record will speak for itself in that regard.
Okay.
But it's your position then that the applicant does have that burden?
In which regard?
Well, you just said the applicant has in this case, right? That was your testimony.
For the requirements that apply to the project,
Right.
yes, they have.
Okay, and it was the applicant's burden to do that in your estimation?
So as long as we have the information, the code doesn't require who it comes from. So you're saying applicant, so to be technically correct, I'm going to disagree with that. Because as long as the application is present, we don't need to know who put it together, as long as the information is there.
Okay.
That's required by ordinance.
Right, so long as the evidence is there, right, there has to be some evidence in the record, right, to support the application, approval of the application.
For the components that are required by code.
That's my question. Okay, thank you. And so the record will speak for itself as to whether or not that in fact existed, but you agree that that's a requirement. Thank you. Can you articulate why the amendment to the zoning ordinance furthers the orderly development of the city? Why does putting a gas station there do that?
You're referring to 113601? Excuse me. No, that's not. Remind me again, which is that reference to?
The development plan approval requirements?
I'm not sure which.
I guess I'd like to know what
All right.
ordinance you're referring to too, so I can make sure, because I think I know what you're going with this, but I want to make sure I'm looking at the right ordinance. Are you looking at 11, are you referring to 1136.01?
I'm not, but let me just withdraw the question. Let me ask you a different question. So that I'm clear on this. As of August 3rd, 2022, when the planning commission approved the development plan, there were no subject matter experts that presented testimony at that point in time. Correct?
I believe that is correct. I don't,
Okay. And as of August 3rd, 2022, there was no wetland delineation, there was no environmental remediation plan, and there were no traffic studies that were presented to the planning commission as of that date, correct?
correct.
All right, I have nothing further. Thank you.
Thank you. Use redirect.
Just very quick redirect. Go ahead. Sorry. Mr. Begoni, I just want to clarify the record because it's to the experts' comment. Do you know who Brian Smallwood is?
I do.
Is he sitting in the room?
He is.
Who's Brian Smallwood?
He is the engineer for Meyer on the development.
An engineer and expert on engineering issues?
He is, and I'll,
And did he
August,
speak before the planning commission, before they voted on August 3rd,
I believe he spoke on August 30th.
on August 30th? I'm sorry, was there another person, Lonnie,
West.
another, do you know who that is?
She is also an engineer with Wilper.
And she testified before the planning commission before they voted on August 3rd?
She did.
Did Mr. Chris Jones, who's the senior real estate manager for Meyer with 30 years of real estate development, testify before the planning commission before they voted on August 3rd?
He did.
When we talk about orderly development, does the city council determine what the orderly development of the city is?
They do.
And when they amend the zoning code to allow gas stations and retail for parcels of 5 acres or more, is that part of their job to determine the orderly development of the city?
It is.
Thank you. At this point,
Do you have any recross?
I have one question, Mr. Zollinger. May it please the board?
Yep.
My question is this. Was there any statement during the record of, it was a meeting with respect to amending the ordinance? Was there ever any statement, ever anything that referenced precisely how amending the zoning code to allow gas stations in the North Gateway District, how that would further the orderly disposition, or excuse me, the orderly development for the city? Was there any statement along those lines?
Again, I wasn't at all the meetings, so
So you're not able to offer any testimony as to that. Is that fair?
fair.
Okay, thank you.
Mr. McLuth?
we call Mr. Jensen.
Yeah, it was hard for me to see when I looked at the video with the planning commission meetings. Is this how you did it with you put the witness over there, and is that how we're doing, did it? Okay.
But I think, yeah.
The screen was very small and blurry, so, all right, that's fine. If that's okay with everybody else, we'll do it this way.
So, Mr. President, testimony you're about to give will be the truth, the whole truth.
Mr. Smith, if you can identify yourself for the record, please.
Yes, I'm Jim Smith. I'm environmental consultant with Brownfield Restoration Group.
Can you explain to the board your role with this project?
Yes, with this project, my firm is providing environmental assessment and oversight of cleanups. I am a certified professional under the Ohio EPA's Voluntary Action Program, which is the regulatory program under which this work is being conducted.
Mr. Smith, have you been involved in other projects in this area that the board would?
Yes, I believe they would. done voluntary action program work on several sites in the area. Possibly you may be familiar with the old Hercules engine plant in downtown Canton, which is now luxury apartments. We took that site through the voluntary action program. There's a Stein Industrial Park in Canton that we also took through the voluntary action program. Over in Massillon, there's the Massillon Energy Industrial Park that we also took through the voluntary action program. So we do a lot of this work. We do it all over the state. We've done several projects in
And can you explain to the board the status of your work on this project? Where the work stands?
Yes, we are done with the assessment work and are, and have prepared the remedial action plan for the site. And, are working with, Meyer to get that scheduled and implemented.
You've heard Mr. Swing, I think, every time he talks about the site, emphasize how very toxic it is and how, can you describe the board if you're, in your professional opinion, this site can be safely put to retail use?
Yes, in my opinion, there's absolutely no question that it can be. It's, not as contaminated as many sites that we have completed the voluntary action program. It certainly has issues, otherwise we wouldn't be taking it through the voluntary action program, but I've seen nothing that would indicate that it can't be done.
Will any of the remediation work or any of the work that you're doing have any negative impact on any of the surrounding?
Quite the contrary, it would be very beneficial to the surrounding areas, especially if you contrast it with the 40, 50 years that the unpermitted dump existed, uncontrolled and unremediated. It will now be, it has been thoroughly assessed, will be cleaned up with Ohio EPA oversight to meet standards. I mean, the contrast is stark in terms of what it was versus what it will soon be in terms of protectiveness to the neighborhood, to the community. That's what the voluntary action program is all about.
Does the state try to encourage these kinds of remediation?
Absolutely, they do. That's why the program was created, was to address brownfield sites like this.
Was to address,
I'm sorry.
say again. Was created, was to address.
Oh, I'm sorry, yeah, it was created to address sites like this, brownfield sites.
You've heard Mr. Swain talk about no further action letter not being until 2023, or not sure where it's going there, but do you have to wait until you have the no further action letter before you can do anything on the site or begin your project?
No, it is, and that is certainly one primary distinction of the voluntary action program is that it is voluntary, is not a requirement. Myers, for liability protection reasons, I presume, that's would be the reason you would do it, is to get from the state sign off that you have met all their standards, and in return for that, the state will grant a covenant not to sue for those issues that have been properly investigated and remediated to their standards. That's the whole point of the program, but it is voluntary.
And in your experience, does the city ever regulate these environmental issues, or are they addressed at the state and higher level?
No, our environmental work is regulated by the state, at the state level or the federal level. That's where environmental regulations come.
Right over.
All right, thank you. Mr. Swing.
Thank you, Mr. Zollinger. We met previously, Mr. Smith?
Yes.
The remediation report you testified to, what was that prepared?
Remediation.
Was it assessment?
Our assessment work is being compiled into a voluntary action program phase 2 assessment. And the remediation plans are also being developed.
So they're incomplete at this time.
They are incomplete in that the environmental assessment and cleanup report under the voluntary action program are not complete until you turn in your no further action documentation when that work is complete.
So maybe I misheard your testimony, that there's no new report or new written assessment that's been compiled and produced for the city of East Point.
We do not have an assessment report compiled
Because it's not complete.
because it's not complete in the sense that it is not ready to support a no further action.
And that won't take place, the no further action determination, that won't take place until late winter of 2022, early 23, February, March, is that what your testimony was previously?
That is correct.
Okay, and the covenant not to sue, that's not something that you would envision securing in any event until November, December timeframe of 2023, is that correct?
Typically, it's about 6 months of review by the EPA of the no further action documents. So roughly 6 months after we're completed with the no further action.
Mr. Smith, the property was strip mined prior to 1968, correct?
My understanding.
Okay, and after the strip mining ceased, the property was purchased by the Hoover Company, who dumped unknown quantities of plating, rinse, waste, and solvent waste from degreasing operations. Does that sound true?
That sounds correct.
Okay. There are later aerial photographs of the property that show that it was used then as a landfill, right? I think you testified to that.
Yes, yeah, and not to be too in the weeds. Technically, it was used as a neighborhood dump. It was not a permitted landfill.
Do you know whether or not there are metals in the soil?
We have found metals. Sure.
Okay, how about volatile organic compounds?
Yes,
Okay. How about polynuclear aromatic hydrocarbons?
I believe so.
What about total petroleum hydrocarbons?
Yes,
How about polychlorinated biphenyl,
I think,
biphenyls?
yes.
Those also,
Yes.
also known as PCBs, right?
Correct.
Is this a property where the EPA would ever allow a playground?
Ever allow a playground, not in its current condition.
What would have to be done to make it safe to have a playground there?
It would have to be cleaned up to residential standards.
Okay, and are those different than the standards that we're talking about in terms of the Meyer development?
Yes, the Meyer development is targeted for cleanup to commercial industrial standards.
So the lesser standards, right?
The standards are less stringent, if that's what you mean.
Would Meyer, for example, be allowed to have as a courtesy or as an accommodation to the community, to put a playground outside of the Meyer Super Center? Under the regimen that we're looking at?
No, they would not,
Okay, why is that?
because it wouldn't be cleaned up to residential standards.
What about potable drinking water at the site? Is there gonna be potable drinking water under the remediation plan as you envision it?
No,
So it's not gonna be safe enough to have a playground or clean drinking water, but it's gonna be safe enough for people to shop and buy food.
Yes, that's the way the program works. Okay.
And when you talk about not holding up things, in terms of moving forward with the remediation, right? There's no construction that can take place until the remediation is complete, is that fair?
No. If what you mean is it can't, that's not correct. It could, it wouldn't make a lot of sense. What is most cost effective is that site preparation and site cleanup go hand in hand. That's what's currently planned.
Okay, but construction's not gonna take place until the remediation is complete, is that your understanding?
That's my understanding.
Okay. And who's paying you to testify here today?
Who's paying me to testify? Kerbliak?
And do you know, by the way, do you know who's gonna be responsible for paying for the remediation?
I am not aware of the contractual obligations. Our work is being paid for by Meyer.
Do you know how much it's gonna cost?
Not
Objection
for certain.
relevance.
And have you anything new or different to bring forward in terms of reports, assessments, studies, than what you brought forward on August 30th of 2022 when you testified?
Well, I'm not sure I understand that question specifically. I mean, we've done work since then, if that's what you mean.
Right. But that work is incomplete. It's not to an end point.
That work is not to an end point. Sure. It won't be until we compile NFA documents. No further action.
I have nothing further. Thank you, Mr. Smith.
Thank you, Mr. McLuhan, any redirect?
Just very quickly. I just want to make sure that the record is clear. When Mr., I think you're talking about different reports. When Mr. Swain asked you to submit any reports, I think he said to the city. Are you submitting any report? When you talk about reports being submitted, who are you talking about submitting those reports to?
Well, that's certainly a good question because when I was talking about no further action documentation, that will be submitted to the Ohio EPA as part of the voluntary action program. We certainly are reporting to Meyer on a weekly basis in terms of our progress. We have status meetings with them.
No, I get that, sorry, I don't mean to interrupt, but in terms of official reports for the work that you're doing, that is dealing with the state, not interacting with the city.
Oh, that's correct.
And are you aware of any plans for Meyer to place a playground at the site?
No, we specifically, to the contrary, specifically discussed with them what the cleanup standards would be, and that would be commercial industrial, because that's what they intend to do with the project.
And that is their choice whether they put a playground or not.
Well, yes, it is their choice. If they wanted to clean up to a residential standard, they could put a playground, yes.
And Mr. Swain went through a laundry list of words that I think to us non-engineers or kind of sound scary. Metals, hydrocarbons, all that kind of stuff. Anything here that you wouldn't find at any other site that you clean up?
Well,
Objection overbroad.
yeah, we have found all of those contaminants. Those are typical contaminants that we find at brownfield sites. Not every site has all of them. Every site is different and unique in their concentrations and which ones they have, but none of them are, none of them stand out to me in the work that we do day in and day out as unexpected.
No further questions.
Thank you. Any recalls?
Nothing further, Mr. Sullivan.
All right, thank you.
Thank you.
We call Mr. Charles Gill Snyder.
Counsel, just so you know, like, we're gonna let you note your objection, and we're not gonna rule on them here, but you're allowed to note it for the record. Just make sure you speak up enough so that the court reporter can hear Mr. McLoof, I think, did you catch his objection in the last? Okay, I just want to make sure. Okay, go ahead.
If you could swear.
Yes. Solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth.
I do.
Full name.
Harold G. Snyder.
Mr. Snyder, can you explain to the board who you are, what your work history, your professional background?
I'm a real estate appraiser and consultant. In my 47th year, family 80th year. We have offices in New York and in Star.
And in your history of doing appraisals, what kind of appraisals do you do?
There's really nothing we haven't appraised. We do 3,000 round number residential properties a year, 4,500 properties like the Meyer or commercial. Do a lot in the healthcare industry, contamination projects, domain, much the gamut.
And have you been accepted as an expert in appraisal by any courts? Body?
Numerous hearings, local courts, district courts, federal courts, and it has.
And are you familiar with the Meyer site?
I am.
Have you considered whether the development of the Meyer and the gas station would have any impact on the surrounding property?
Several thoughts on that, pointed out by Mr. Smith in terms of the advantage of contamination perspective to the neighbors. It's a blessing. In terms of property values, I posit that the Meyer development is an enhancement to the neighborhood. Values to increase where Meyer goes. I can point specifically to Fulton Road and the former Tam O'Shanter development out there and what's happening up and down and across the street.
Thank you. No further questions.
Thank you. Mr. Slane.
Mr. Snyder, so the good news is, I recognized you sitting there. The bad news is, I had written down the wrong name. So nice to see you again, Mr. Snyder. Have you done any work beyond the work you've done when we last met on August 30th, 2020?
No, sir, I am.
Okay. And on August 30th of 2022, I asked you this question. I said, other than your general experience over the years, can you tell the planning commission what specific action you took in regard to market analysis of the surrounding areas? And your answer was, sure, fair question, none whatsoever. That's still your answer today, is it not?
Yes,
All right.
nothing engaged.
All right, thank you.
Thank you, sir.
No further questions.
Okay, thank you. Any other witnesses?
One last witness.
Okay.
We call Mr. Greg Soltis. He has a PowerPoint presentation. We can get him sworn in.
Okay.
Greg, Greg,
Yes, O-R-Y.
and last name, Soltis, S-O-L-T-I-S. Raise your right hand, please. You solemnly swear that the testimony you're about to give will be the truth, the whole truth, and nothing but the truth. I do.
Mr. Soltis, if you could identify your professional background.
I work as a senior designer at RDL Architects with a background in architecture. I'm an AICP certified planner. I also teach urban design and neighborhood planning at Cleveland State, and I serve on the downtown Cleveland design review committee.
And Mr. Soltis, have you examined North Canton zoning code and the appropriateness of the Meyer project for the site where it's being located? I understand you've prepared a presentation.
Yes, I mean, I pass these out to everyone.
Sure, of course.
Wrong angle for you.
Thank you.
I don't know if anyone else needs one.
Okay.
Instead of me asking you one question, I'll turn it over to you to do the presentation for the board and then I'll do it all.
Okay, so, in preparation for today, basically, I looked at the zoning code and then did a sort of analysis. I mean, and approaching this as a planner would say I were to do development in your city and had to design something, kind of approached it that way. And so I took some text from the code, I'm just gonna read through it quickly, but the, section 1136.01 that states the intent of the zoning code. So it says North Canton's Main Street is the city's central commercial corridor and is comprised of 5 primary districts: Main Street Center, Main Street North, Main Street South, Main Street North Gateway, and Main Street South Gateway. Together, the Main Street districts. These districts are established to promote the development of a higher density, more consistent, walkable urban fabric and attract increased investment in key commercial corridors and nodes. The Main Street districts are intended to respect existing surrounding development patterns while promoting desired development patterns within each district. So then as a summary of that and a takeaway, the 5 Main Street districts are intended to, 1, respect the existing surrounding development patterns, and which is always a good starting point whenever you're designing anything anywhere. And then 2, promote the desired development pattern. So, in quotes, promote the development of a higher density, more consistent, walkable urban fabric, and attract increased investment in key commercial corridors and nodes. On the next slide, oh yeah. Can you move it to the next? Go to the zoning map. So this is the zoning map that shows all the different zones. So the blue zones that are along Main Street going north and south, you can see the zone that we're talking about specifically is where I placed the red dot. So that's the parcel that we're talking about. And that is the Main Street North Gateway. Then, south of that is Main Street North. South of that is Main Street Center. South of that, Main Street South, and then Main Street South Gateway at the very south before that big yellow area. Next slide. The next one, please. So a general concept in urban planning or planning in general is the zoning transect, which really is a nice way to look at a town. Now, this can operate in a number of different ways. In a bigger city like Cleveland, where the city was built out, some of the suburbs don't have their own downtowns, and they're just part of the urban fabric or sprawl of the city. But North Canton is its own town with its own downtown, has a historic downtown. So you can see the urban center zone, the general urban core, the suburban zone, etc. So as going out from the center of downtown, there's lesser density, a little bit more space around buildings. It's just a general development pattern. And if you go to the next slide, one of the reasons why, or a lot that you can learn about when you look at any city, is by understanding what's called urban morphology, or how cities change or develop over time. And basically, if you look at number 3, the biggest thing here, it considers the built landscape type as a morphogenic unit because it's defined by time, right? So different things develop in different ways in different times because of transportation options we had at the time, the economy, things like that. Next slide. So there are 4 general morphological elements: the street pattern, which make up blocks, the parcel or plot pattern, which is the actual, how each individual parcel is defined, and usually somebody owns each individual parcel, the buildings, and then the land use. On the next slide shows that the street pattern and the parcel pattern are the most enduring and tend to change the least. So there's a lot that you can learn about a place just by looking at those. And then the buildings and the land use tend to change more. The buildings get knocked down, the building gets used for a different use. Next slide. And this just talks about blocks. Generally, blocks that are walkable blocks are between 200 to 300 feet ideally, but they can be up to 600. And this is based on our bodies. And when you look at over time, people walk places mostly. So the farthest that our eyes can really start to discern movement is about 330 feet. And then about 60 to 70 feet, you can start to see features on people and identify, who someone is. And then you get more detail as you get closer. So that's why, our ancestors kind of built places like that. And North Canton is old enough that the original settlement pattern of the town fits into that. So if you go to the next slide, trying to like take the zoning map and then just make it real clear so you could just see the parcels and the blocks. And you'll notice that in the center of town, the blocks are small. They are like a 200 to 300 foot block size, with the exception where the main industry was in downtown, which was the Hoover building, the Hoover plant. But most of the blocks in the core of the city are small, and they start to get bigger as you move out. So you can see in the center of town, which is typical of 19th century planning, and downtown Canton, from my research, I think was founded or downtown North Canton in 1831, I believe. So that's a tighter, more rectilinear street grid with no dead-end streets. There's the existence of alleys in downtown North Canton, which is, very typical of very old places by American standards. Smaller blocks, 200 to 300 foot ideal, really nothing more than 600 feet in the core of town. And then narrow parcels as well, because when you didn't have cars, it was really important to have access to the street. You needed frontage, so the parcels may be narrower, maybe they were deeper. On the edges of town, you'll start to notice like the influence of trains, but especially automobiles from the early to mid 20th century on, and you can see continuous curvilinear layouts, larger blocks, wider parcels, and the introduction of cul-de-sacs, so streets that kind of go nowhere, right, or end. On the next slide, what I did is created a map showing all the building footprints, and that's another great way to be able to see what are existing development patterns. And so again, you can see in the center of town, there are larger buildings that are institutional buildings, and they tend to be placed closer to the street. And then the very large building in the center of town obviously is an industrial use, but it's different than the industry that was built today in that it is placed directly up on the street. You'll also see houses and other small retail buildings close to the street and more packed together. And what that does, all those buildings kind of create a definition to the street. Whereas as you move out of town, the buildings become more objects in space. And if you look as you move up Main Street, as you get past 7th Street, the buildings start to get, the retail buildings a little bit bigger, they're a little more loosely, apart from each other. And when you get to the site, that we're talking about today, the area around there has buildings that have parking lots in front of them, are set back, they're much larger retail commercial buildings. It's from a different era and typical of that neighborhood and that part of North Canton. So if you look at the next slide, and in looking at the zoning, yes, there's a general intent for Main Street to be like the primary street of North Canton and to be walkable, but there's a gradient to that walkability. So I would say that anywhere there's a sidewalk can be called walkable. Some places are more walkable than others, and on the edges of town, there are sidewalks. And you could, if you chose to, if you live on the edge of town, walk all the way into downtown. Downtown, there's more to see, more to do, more places to go in closer proximity to each other. So walking makes more sense than it does necessarily on the outside of town unless you want to get your 10,000 steps in. So there are many different places within the code where there's nuance between the different districts for Main Street that allows that gradient of development. And if you go to the next slide, it does say in the code that is to the general intent of the code is to make that North Canton more walkable, to make it better. So there's this idea of making it better than it currently is, and every place can be better. But I did notice also that many of the implementations that have been done already kind of show the thinking behind the city and how it's viewed as one continuous place that is nuanced and it has a gradient to it. So in downtown, you can see that there are sidewalks that have what we would call a defined amenity strip. So if I could real quick, like on a residential street, right, you might have just a 4-foot wide sidewalk because there's not a lot of pedestrian traffic on a street with single family homes. You really, most of the time, only need enough space. Our bodies are about 18 inches to 2 feet wide for one person to kind of walk down the street, maybe two. As you get into places like where there's more pedestrian traffic and retail storefronts that are on the sidewalk, you need a wider sidewalk. And then a sidewalk can be divided up into different zones. There's the curb zone. On the curb, if there's on-street parking, it might be more than 6 inches for the curb because you want enough room for a door to open and someone to get out. Then there's an amenity strip, which is where those red bricks are, where the street lights are, signs, and it usually provides some sort of buffer for the pedestrian to the street. In this case, it's primarily a visual buffer signifying you walk here, here's a little space to keep you away from the cars. And then there's the pedestrian through zone, which I mentioned can be different sizes depending on the amount of traffic. And usually a frontage zone, which like in downtown North Canton, there's that really cool restaurant I got to go to once that, they have like a little outdoor patio, so that's like a frontage zone. Yeah, that place is great. So the next slide shows that out on the Gateway District to the north, there still is a walkable sidewalk, but it's different. The light fixture is bigger, it's taller, it's not as short and more human scaled as the one downtown. There is an amenity strip, but it's more stamped concrete. It's not a different color or a different material. It's stamped concrete instead of actual bricks. But there's a sidewalk there and it's walkable. And the other thing is I had here, which I neglected to put in your presentation, but you've all seen this image, which is a really wonderful illustrative image. And the zoning code actually differentiates between the two types of imagery in the code. Illustrative images, which are intended for general intent, and then diagrams, which are intended to express specific things about how something should be placed or how tall it should be, for example. And this is a really great image that I think is possible in downtown Canton, but this would not be possible all throughout Canton unless you decided as a community that you wanted to ramp up your density to about 10,000 people per square mile. If you look at places like this that exist in northeastern Ohio, you're looking at a place like Lakewood, which has 10,000 people per square mile. North Canton has about 2,800 people per square mile. But it's most certainly doable in downtown North Canton for the residents of North Canton, even as a destination for people, live in northeastern Ohio to come here and do shopping or have a cool experience. And then the last slide, just going over the general criteria for all conditional uses. There's a lot here. Most of it has to do with, what all zoning codes and building codes deal with, which is the general safety and welfare of people. Myers has built many different stores, and that's also what the city planning staff and the other staff at the city are for, to make sure that all those building codes and other codes are met. But when it comes to will not be detrimental to property values in the immediate vicinity, will not restrict or adversely affect the existing use of adjacent property owners, will be designed, constructed, operated, and maintained so as to be harmonious and appropriate in appearance with the existing or intended character of the general vicinity, and that such use will not essentially change the character of the same area. I would argue that what is being proposed is in keeping with the character of this area that was, shown on those slides that showed, the building footprints, the block structure, the building massing, the setback, all those things are consistent with the other buildings that are around it. And I guess if you have any questions, I'd be happy to answer them.
Mr. McLuth, do you have any more questions?
Rarely does a lawyer stand without anything to say. Thank you very much.
Mr. Swing?
Hello, Mr. Soltis.
Hello.
You didn't testify on August 3rd, did you, for the planning commission?
No.
You didn't testify on August 30 either, on the continuation of the adjudication hearing, is that right? When were you engaged?
So,
Let me ask you something. Do you know whether or not the city actually intended to, I think your word was ramp up, right? Let me back up. Are you familiar with the zoning code amendments that occurred in 2021?
I'm familiar with them in a general sense, but not in detail.
Do you know that they were intended to prohibit gasoline stations on Main Street?
I do know.
And I guess that's exactly the point. You don't know, do you, whether or not it was the intent of the city in 2021 when they enacted their amended zoning code to actually ramp up density?
Well, it says in the zoning code that that's part of the intent. So I would assume that it's consistent with what's in the zone.
Thank you. So it likely was the city's intent to ramp up density throughout that district. Thank you. Do you know, or have you made assumptions with respect to environmental remediation of the site and its impacts?
It's not my area of expertise.
So those are assumptions you made?
When you say environmental, are you referring to like it being a brownfield site?
Yes. Yep.
I don't remember saying anything about that, but, so, I don't believe I referenced brownfield site.
Okay, do you know whether, have you seen the general development plan by chance?
Yes,
Okay. And do you know, does it provide for, the gas station, does it provide for a pedestrian walkable environment, friendly walkable environment?
it provides for what you see on the screen there, which is consistent with what the city defines as a walkable environment for that district.
That's not the gas station we just looked at. Those
No,
plans.
this side,
Okay, but do you know that that's the sidewalk that they're including in the general development plan?
I don't know for sure, but I would,
You're guessing, right?
well, normally, I am making an assumption.
That's fair. I just want to know what they are.
But normally, the commercial development would end at the sidewalk, and the city is responsible for the sidewalk, not the commercial developer, unless they have some special agreement where the developer says they're gonna do something additional, and the city would, yeah, that's great.
Okay, so as you sit here, or as you stand here this afternoon, sir, are you able to testify that the general development plan for the accessory conditionally permitted gas use will promote a walkable, pedestrian-friendly environment?
Fine,
Are you able to say that categorically?
meaning,
Are you able to agree with that statement? That the general development plan, as it's submitted, will promote a pedestrian-friendly, walkable environment?
well, insofar as what's defined for that district, in that there is a sidewalk on the street, and the sidewalk has 3 of the 4 elements you would normally experience on a sidewalk.
Do you think it comports with what I think you described as what you assume to be the spirit and intent of that amendment to ramp up density?
Yes, but there's different reasons why you would, and there's different reasons why you would ramp up density, and density can look different in different places. Like, simply adding another store adds density to this area. But, density of what's in downtown Canton is maybe not appropriate.
That wasn't the same type of density you were testifying to earlier, though, was it? When I asked you about the intent of 1136, and you agreed with me that it applied to all of the zoning classifications on Main Street, right?
It does in a gradient.
Okay, but in each one of those districts, right, you agree that it ought to promote a walkable, pedestrian-friendly environment?
I do.
Okay, I have nothing else. Thank you, sir.
I know the limits of my knowledge and what I can do. I can't do any better. Thank you.
Thank you.
And with that, I think we turn it, if they wanted to do closing statements. we're ready.
Yeah, we'll go to closing arguments if there are no rebuttal witnesses or anything like, any rebuttal evidence. We will go ahead and, I'll let, Mr. Swing go ahead and start. And then Mr. McLuhan, then in rebuttal by Mr. Swing. I place a time limit on this, but, just so you got, we've been here a while and we've read through everything, so you can use your discretion. I'm not going to stop you, but just keep that in mind. Is everybody okay? Anybody need to take a break or anything? You good?
Can we take a quick break?
You want to take is everybody all right with a 5-minute break? Yeah, why don't we do that?
I'd like to accommodate whoever needs accommodated.
Yeah, we'll do that. 5 minutes.
You're good. I know it's what I'm afraid of.
That's an act.
We're gonna,
Catch up.
yeah. Oh,
It's right there.
I know.
Do it.
All right,
The only time.
we're gonna get started. You ready over there? Okay. All right, we're gonna proceed now with closing arguments. So Mr. Swing, whenever you're ready, you have the floor.
May it please the board, thank you for your patience and thoughtful consideration today. I greatly appreciate your public service. I would ask that with regard to any findings of fact or conclusions of law, that you guys actually look to the record of proceedings that pertains to each of these applications. There are two separate applications, there are two separate appeals, they have two separate records. One of the records deals with the development plan approval. That occurred on August 3rd. I would submit respectfully to the Board of Zoning Appeals that you are bound by the record that existed on the date when they made that determination on August 3rd. And so you should only consider that evidence at that moment in time. Same is true with respect to the August 30th approval of the conditional accessory use for the gas station. I would submit to you respectfully that you're bound to look to the record as it existed on August 30th when the Planning Commission made that determination. The question before the Board of Zoning Appeals is whether or not the applicant has presented by a preponderance of the evidence credible, reliable, and substantive evidence to support the applications. And I would submit to you respectfully that the applicant has failed for the reasons that we've articulated, for the reasons that are already set forth in the record, for the reasons that are set forth in our letters that were requested by the city that we have furnished. Those being September 16, and I think most recently, can't remember the other day, but it's very recently, on each. At a minimum, you should reverse. If you're not, excuse me, if you're not prepared to reverse, at a minimum, you ought to remand both of these back to the Planning Commission. That's the proper authority under your zoning code to approve a general development plan, and it should be provided with and present testimony and evidence to support the application. You should not expand, backfill, augment, supplement the record as it existed then. You guys should do it in order. You guys should look at the principal use, approve the principal use, then look at the accessory use, approve the accessory use if you think it's supported. But it's out of order right now and it's unsupported. And for those reasons, I would ask at a minimum that this body remand both of these matters back to the Planning Commission. Thank you.
Thank you, Mr. McGlue.
Thank you very much, Mr. Chairman and members of the commission. I'll try to be very brief. I hope we're listening to what Mr. Swing is saying. He wants to turn the development process in North Canton into a trial. He's literally asking you that every time a development comes before the city, he wants to have a full-blown trial before the Planning Commission on whether the development should happen or not. That's not how development works. You have a developer, they have their project, they come before the city, they put the project in front of the Planning Commission, the Planning Commission considers it. If the Planning Commission has any questions, they ask it of the developer, and they move from there. You are literally being asked as if this is a federal court with the amount of evidence and everything that needs to happen. That's just not how development works, and that's the wrong image that North Canton would ever send to any development in the future of the city, that it's turning every development into a full-blown trial. The one thing that's been missing in all of this, we've heard all this testimony, what's the adverse impact on Acme? Have you heard any testimony about water flowing into the Acme site, environmental contamination going into the Acme site, the visibility of Acme being disturbed, anything? This is entirely about competition. This is entirely about a business in town coming to the city and saying, you go pick who wins and who loses in the free marketplace. Use the zoning process to pick who wins and loses. Quite frankly, tortuously interfere with a contractual relationship over a purchase of property to use the zoning process to interfere with that. That is a very improper use of the zoning process. With respect to the testimony, we've heard we've heard from, when the combined evidence that you have, you've heard from the city's own staff and experts, plus two land use planners, Sean Suter before the planning commission and Greg Soltis before you, in favor of this application and in favor of the conditional use and the general development. There is testimony in the record from true traffic engineers. There is Myers, traffic engineer at Wolpert, who prepared the traffic report, and the city retained its own traffic engineer who reviewed it and confirmed the findings that there are no substantial impact here and that the traffic is appropriate. You've heard from Jim Smith about the environmental issues and how this actually improves the area. It doesn't have any negative impact. The wetland report is in the record. You've heard from two valuation experts before the planning commission and Mr. Bill Snyder here. Again, with the criticism that they didn't prepare a full-blown appraisal. This is not a trial about the value of real property, that it went up 2 cents, 5 cents, 50 cents. This is a question about whether there is an impact on the value, whether it's a negative or positive impact. And all the testimony unanimously has been that the impact on the property is positive and that there is no negative impact. And again, the issue here is not the value of the property. Adverse impact is really more of those structural, physical issues. But to the extent that they want to make it about economics, you've heard from the experts that there is no impact here. There is the testimony of Rob Graham about the procedure in terms of how the city approves all the issues about which they complain, the traffic impact, the stormwater management, the wetland, how the city manages all of that. And at the end of the day, what's the city's safeguard? They say, Meyer promises you to do all of this stuff, and what if Meyer doesn't do it? Yeah. Meyer doesn't do it, it doesn't get a building permit. The safeguard is already in place to make sure that all those things are taken care of. You don't have to handicap and stop the zoning approval process because engineering issues have to happen in the future. I've told you about their witnesses, the conflict, the qualifications. I'm not going to go into that anymore. The one thing I would agree with Mr. Swing about is, yes, we agree that the board should consider both approvals separately and make a determination on each one separately, recognizing all the evidence that's been put in support of each. Thank you very much. We appreciate the work.
Thank you. Mr. McClure, one question. You agree the standard of review for us is de novo,
Say
meaning,
again.
I'm sorry, the standard of review for the board here is de novo, meaning we take a fresh look, no deference to we make our own judgment. We give no deference to the planning commission.
Absolutely, and that is supported by, that is supported specifically by your code.
Okay.
That's why there is a hearing. That's why you have a public hearing. I mean, again, it's talking about the agenda, meaning the actual code in section 1179.03 is that the board has a public hearing and makes a determination. So absolutely, it's de novo. And this board has the ability to basically occupy the position of the planning commission to make those opinions.
Okay, thank you.
Thank you very much.
Mr. Swing, I have same question for you. Would you agree that that's the standard of review here for us?
Mr. Zollinger, I agree that is the standard of review, but you're not permitted to expand the record. You're not permitted to conflate the records. You're bound to sit. If you're going to sit in the chair of the planning commission, then you ought to look at the evidence that it looked at.
I guess my question for you then is, what legal authority says we cannot look at new evidence and we're restricted to the record before the planning commission?
Your zoning code, your own zoning code doesn't provide for that.
Where does it say we're not allowed to do that?
Where does it say that you are?
I'm just asking because I've handled lots of hearings on de novo appeals and
Right.
Not in, before administrative proceedings, not courts, and the higher tribunal is allowed to look at new evidence. So I'm just wondering.
The Ninth District Court of Appeals isn't allowed to look at evidence beyond what a trial court considers when a case is on appeal from the trial court to the Ninth District Court of Appeals. The Ninth District Court of Appeals is bound by the record below. And by the way, with regard to this isn't a court of law, and we don't want it to be a court of law, and you guys don't want to adjudicate every project like it's a court of law. Please, let me reassure you, it's not, I take no joy in being here just for the sake of being disruptive. It's a 2506 administrative process. I am obligated to make a record before the administrative tribunal. And the applicant, likewise, was required to make a record before the administrative tribunal, because if it goes to a trial court, the trial court, with some exceptions, is going to be bound by what was established below.
Right.
So it's not to create, more work for anyone. It's merely, and by the way, Albrecht remains unapologetic about the fact that it's been a resident in the city, and I frankly take umbrage to this issue about competition being the only or the reason or the intention motivating its actions here. It is a resident of the city. It has been a longstanding resident of the city. It has been a fine contributor to the city, and there is ample evidence in the record beyond competition that there are deleterious effects that may result, right? Because Meyer comes up and swallows up a bunch of consumer buying that would go elsewhere, and then you're going to have dilapidated and deteriorating surrounding area because those businesses are going to go under. That is something that this board may consider. That is something that the Planning Commission could consider. And so I think Gil Snyder, I mean, look, here's what I would implore the board. And I know you're thoughtful, and I know you're hardworking, and I know you're intelligent. Tie out to the statements that are being made today. Tie it to the record of proceedings. Find the page in the transcript. Find the document. Find the evidence. Because with all due respect to Mr. Snyder, who's a perfectly delightful gentleman, he did nothing to prepare for his testimony. He is a hired mouthpiece. And so I think you should wholly disregard that. That certainly doesn't meet the burden that is requisite for the applicant. And with that, I recognize it's been a long day, and I appreciate your attention to this. Thank you.
Thank you.
If I may, just very quickly, I'm not going to respond to any of that. I think we're past all these discussions. Just the issue on the appeal. Again, you look to your own zoning code. It specifically provides for a public hearing, which is the introduction of evidence. Not only does it have no prohibition on the parties producing additional evidence, it specifically allows the board itself to request additional evidence and to request expert reports when you look at 1179.06. So it goes even above beyond us giving you additional evidence. It allows you to request additional evidence. And I would think of this, if you want a comparable from the administrative world, think of a board of revision hearing on real property valuation. If you appeal it before the Board of Tax Appeals, it's de novo, and there's introduction of additional evidence. We're almost in the same way if you want to think of it here. Mr. Swing is trying to conflate the appeal from this board to the common police court, where there is a specific prohibition in the revised code on the expansion of the evidence, somehow trickle it down to the appeals within the city. We're still within the city structure. There's no limitation on any of
Yeah,
these.
and Mr. Swing, I'll let you respond to me, but I like, well, your courts have rules binding them to review just the record. Administrative proceedings like this one, I mean, I'm asking because if it's somewhere in here that I'm not seeing it, where are we restricted to what happened below? Where is there a rule that says, usually when I see review, you're only restricted to the record, as a rule that says you can only look at what the record below. I don't see that here. In other administrative settings, in appeal settings, where there isn't a rule, they're allowed to look at new evidence. Is there something, or a decision that says we're only restricted to that? That's what I'm trying to get at.
What I'm submitting respectfully, Mr. Zollinger, is that the zoning code doesn't empower you to consider or to allow additional evidence at this stage of the proceeding. And I would suggest to you that the language that Mr. Had offered previously really only stands for the proposition that you're required to put yourself in the position of the Planning Commission. No more, no less. And the Planning Commission had before it Otherwise, it seems patently unfair that at each stage of the proceeding, right, so the city's not prepared on August 3rd to go forward. So it tables the conditional use, approves the general development plan, comes back on the 30th, presents testimony, right? Because it wasn't prepared on the 3rd, and then it doesn't like what the record looked like on the 30th, so now it's gonna come before the Board of Zoning Appeals and augment and backfill some more. That's a patently unfair process. And I would respectfully submit to you that's not allowed by your own zoning code.
Okay. Thank you. Yeah, anything else, or?
Just a quick reference to the code itself, because again, it doesn't matter what I say, it doesn't matter what he says, it matters what the code says. And the code doesn't say that you put yourself in the shoes of the planning commission and try to see what they did. The court says that you shall have all the powers of the officers from whom the appeal is taken. Not that you put yourself in the shoes of the planning commission, you have all your powers to sit as if you're your own planning commission.
Okay. All right, thank you. I don't know how everyone else on the board, does anyone else on the board have any questions of council this time? Okay. Well, I appreciate this. Both attorneys, I think you both did a great job. I appreciate all of your hard work. I know this is an important issue for your clients. And I know how hard, I've been in your shoes many times. I know how hard it is to do this work. You're getting paid for it though, and I'm not. So there's that. But other than that, I appreciate everything and all of the help and all the assistance you've provided. I am not sure I agree that we aren't allowed to consider new evidence that was presented today. But that being said, even if I will just look at the record from below, and use that to rule myself. And I will first address application number 22, NCZBOA 0005. And that is the appeal of the August 3rd Planning Commission preliminary and final approval development plan. I'd first like to address that agenda item. I believe that the application was properly approved by the Planning Commission with the conditions that were listed there. I specifically, one of the reasons I believe that is I believe Mr. Dalpiaz, the chairman of the Planning Commission, adequately outlined during the August 30th hearing how they have the power to approve things with conditions, and he was citing and reading through chapter 1145 when he did that, and I believe he started doing that on page 138 of the transcript of that proceeding. Now, I believe that also applies to the preliminary and final approval of the general development plan of August 3rd. For that and many other reasons in the record, I believe that decision was correctly made.
Point of clarification, Mr. Chair, which decision are you referring to, just so that the record is clear?
I'm referring to the August 3rd decision. And again, I referenced the application number 22 ZBOA, NCZBOA 0005. I don't know how everyone else feels. I would rather just I will make a motion to affirm that decision in its entirety. And again, I believe, I don't know if I want to adopt written conclusions of fact. I don't know that we're required to do that. I will say, though, that when I look at I agree with the conclusions that Meyer submitted the materials and information required under 1175.05 of the ordinances. I agree that the code does not require a traffic impact study, stormwater management plan, or wetland delineation as part of the submission. I believe the application was deemed complete by the Director of Permits for submission to the Planning Commission, that the Planning Commission had sufficient materials, information, and testimony before it to reach its conclusion that the MS-NG, all caps, district is an auto-oriented district as demonstrated by its layout and uses permitted as of right in the district. Retail is permitted there. Business equipment and supplies sales are permitted as of right. Hospitals permitted as of right. Office warehouse, storage, distribution warehouse, and wholesale outlets permitted as of right. New car sales permitted as of right. Sports fitness centers permitted as of right. Clubs, lodges, assembly halls permitted as of right. There was no evidence that I heard that would impact the walkability of this area by this development. I didn't hear any evidence or testimony that the sidewalks are going away, and the sidewalks out there are wide and very, very walkable. This would increase pedestrian use of that area possibly, although it is auto oriented. It is the code specifically states in the graphic in 1136.09 is illustrative. It is demonstrative of development downtown, and nowhere looks like anything near the subject site. The record demonstrates that Meyer is addressing all environmental issues and is going through the voluntary action program through the state environmental contamination issues are properly addressed by the state and other agencies and are outside the parameters of the city's zoning code. The use fits well within the district and the surrounding area. There is no detriment or adverse impact on any surrounding property. Competition is not a proper basis upon which general development plan may be denied. The conditions placed by the Planning Commission are typical for a project of this nature. They address the concerns asserted by the appellant properly. The zoning board, I move that the zoning board affirm the Planning Commission's grant of the general development plan. In addition, even if there were to exist errors by the Planning Commission, Section 1179.07 provides that we, the zoning board, has the power of the officers from whom the appeal is taken. Based on the entire record and evidence presented before the zoning board, and again, I'm restricting my view just to the record below, just giving, I'll give the appellant the benefit of the doubt there, but I conclude that the general development plan should be approved with the same conditions placed by the Planning Commission. And so I make a motion to approve as such. Do I have a second?
Point of clarification, Mr. Zollinger, if I
Yep.
may. The record below that you're referring to, is that the record as it existed on August 3rd, 2022, or the record as it existed on August 30th of 22?
For this particular action item, August 3rd, because that is what we're acting on right now, is August 3rd. So do I have a second for the motion?
Second.
Any discussion? If there's no discussion, we can call the roll.
Mr. Strub?
Yes.
Ms. Boykin?
Yes.
Ms. Clevenger?
Yes.
Mr. Lemille?
Yes.
And Mr. Zollinger?
Yes. So that, the ruling of the Planning Commission of August 3rd, 2022 is hereby affirmed in its entirety. Now I will go to application 22 NCZBOA-0007. And this is the appeal of the August 30th, 2022 Planning Commission. And that is the approval of the conditional use permit of gasoline station accessory to retail. My view is that this should also be affirmed in its entirety for many of the reasons I've already stated. Again, I will rely on the record established at the August 30th, 2022 Planning Commission meeting, and also, to the extent necessary, the record of the August 3rd, 2022 Planning Commission meeting, where necessary. Again, I would add, I think Mr. Dalpiaz outlined Chapter 1145 adequately in the starting on page 138 of the transcript. And also, again, I would ask that we affirm that in its entirety. Section 1179.05 of the ordinances provides that an appeal to the zoning board of appeals shall stay all proceedings in furtherance of the action appealed from. The appeal of the general development plan therefore did not stay the planning commission's authority to consider the conditional use, because the conditional use approval and general development plan are two separate actions. The city's zoning code expressly authorizes the planning commission to make conditional approvals. As I mentioned, section 1145.03 of the ordinances expressly allows the planning commission to place supplementary conditions and safeguards on conditional use approvals, and that's what they did here. The planning commission properly conditioned the approval on the conditional use on the lot consolidation. It did not have to withhold approval after lot consolidation. The appellant does argue that a section 1136.10 only allows accessory uses with multifamily residential uses only. However, the appellant did not raise this claim before the planning commission. I'm not sure if that constitutes a waiver, because this is a de novo appeal. But nevertheless, I don't think that argument has merit. Even if the appellant did not waive the claim, and the reason I don't think it has merit is that the appellant confuses accessory uses with accessory structures, based on the arguments I've heard today. Furthermore, the council did enact section 1136.05 and expressly allowed gas stations as an accessory use to primary retail uses. It is not our role as a zoning board to change what elected officials have put in place in this instance. This is not a variance where we can maybe modify an ordinance to fit a unique property with a unique problem. This is a situation where I do not think we have the authority to change an ordinance that elected people who do get paid put in place. In addition, for the sake of argument, to equate structures with uses, section 1136.10 of the ordinances sets out a general standard. The city's zoning code was amended on July 22nd, or effective July 22nd, 2022, to specifically allow gasoline station when accessory to retail use as a primary use on 5 or more acres in section 1136.05. So there's no question that legally this use is allowed at this point, and as of July 22nd, 2022. Even though there is a burden of proof here, I agree with that. I accept that. The board here is duty bound to interpret the code in favor of the applicant because the restrictions are in derogation of a property owner's constitutional rights. The first of these principles states that zoning ordinances are to be construed in favor of the property owner because they are in derogation of common law and deprive the property owner of uses to which the owner would otherwise be entitled. And the planning commission, in my view, properly approved the application for conditional use. The applicant appeared before the planning commission and provided testimony regarding the project. But even absent that testimony, the planning commission can rule on the application from the materials submitted without any testimony. We are not a court. The planning commission is not a court, so it's not bound by any rules of evidence. That being said, there was testimony, significant testimony and evidence submitted here. There's no requirement, though, for any testimony under the zoning code or the planning commission, and the planning commission may be satisfied from a review of application materials alone. It's the role in our city, it is the role and duty of the city staff to review the application and provide recommendations to the planning commission, including any recommended conditions of approval. That's a typical process here, and I believe in other jurisdictions as well. A hearing over a zoning application involves the application of the city's codified ordinances, and the city is always a party to any such hearing. In addition, in this case, the property is owned by the city through its community improvement corporation. The city has the right to appear and present evidence and testimony. In my view, the planning commission and this board sit as independent boards, and we make our own determinations no matter who the applicant is or the interested parties may be. So in my view, this application properly meets the criteria for approval with the conditions as attached by the Planning Commission. The evidence supports the granting of the conditional use application, and I find it to be credible. As such, I am going to make a motion to make a motion to affirm the decision of the Planning Commission of August 30th, 2022, before us under application number 22 NCZ BOA 0007. Do I have a second?
Second.
Is there any discussion? Does anybody have anything else to add with respect to this particular application? Okay, with that, then I will call the roll for the vote.
Mr. Lemuel,
Yes.
Mr. Zollinger,
Yes.
Ms. Clevenger,
Yes.
Mr. Strub,
Yes.
Ms. Boykin.
Yes.
Okay, thank you. The decision of the Planning Commission of August 30th, 2022 has been affirmed in its entirety. With that, I do not believe we have any more business to come before the board at this time, so I will entertain a motion to adjourn. Second?
Second.
Okay, we'll do a voice vote. All those in favor? Aye. We are adjourned. Thank you, everybody.